Can we maybe just have 5 more minutes or so?
How about 10:15?
Sure.
Also, the court will advise the jury that today we are adjourning at 3 o'clock.
Yes, Judge.
Okay, thank you. We'll stand in the recess.
All rise. This honorable is right now.
Today we are adjourning at 3 o'clock.
You want to get copies of this?
Yes, thank you. Stand in the recess.
All rise. This honorable is right now.
Today we are adjourning at 3 o'clock.
Okay. They call. Okay. Oops. Just a sec. Something is not muted. They call. Okay. Oops. Just a sec. Something is not muted. They call. Okay.
Advise the jury that today we are adjourning at 3 o'clock.
Okay. Oops. Just a sec. Something is not muted. They call. Okay. Hi, Matt. Something weird going on here. My computer crashed, and I had the thing on another browser, and it seemed to all become unmuted. So we're getting feedback. I think I've got it covered. So the judge just came out and gave us false hope that they were starting and said at 10:15, so that will be in 5 minutes. We had an interesting day yesterday. The nanny slash babysitter was on the stand and told about her experiences with the family, and then we got a police officer, and they started to get into the cell phone data, and went to lunch, and when they came back from lunch, one of the prosecution team said that they had an incident that they wanted to put on the record. They were waiting for the elevator, and the elevator doors opened, and there was a marshal with 2 alternate jurors. And she said that the bailiff said, love you, and so she just wanted to put it on record, and, okay, that's kind of strange, you wouldn't expect that from a professional, but the judge, the defense said, they thought, well, it's inadvertent. They don't think that there's any harm, et cetera, et cetera. And so they went on, and the police officer was testifying. And after a while, the judge said that they needed to have a break, that needed to, something has come up that they needed to deal with. And so the jury went back to the jury room, and they said that the marshal said that the attribution of the love ya was mistaken, and that it was one of the alternate jurors who said it, and not the the marshal, and suddenly it became a lot more serious. Is probably just a greeting. Oh, thanks for letting us continue in the elevator, love ya kind of thing, as opposed to a real fanboy or fangirl. So they excused that juror, and they did this all with no camera or audio, so we didn't get to see any of the discussion with the jurors. So then they brought in the other juror and asked the juror a few questions, and the second juror didn't get excused. So, so I've never seen that before. Certainly one for the books. We dipped a little into the treehouse murder trial yesterday, and I hadn't realized that the defendant was a pro se guy, and the witness who had a deal, he was the getaway driver for what was supposed to be a robbery, was testifying against him. He had got a deal, and the defendant was clearly a lot of animosity between the two of them. So I would dip into that one on breaks today, but we have Chad Daybell is supposed to be having a hearing in, I think the top of the hour. And I think what we might do is, pause the hearing here, go over to Chad Daybell and listen to the argument. John Pryor wants to be released as the, oops, looks like we're starting to go again. He wants to be released as Chad Daybell's lawyer. And that's not going over well.
Have you concluded your discussions, Attorney McGinnis?
Good morning, Judge. Yes, we have. I believe the defense is signing the stipulation right now. There's two stipulations, Your Honor, relating essentially to chain of custody issues with respect to evidence that Detective Riley seized and was subsequently submitted to the state laboratory. I'll just indicate that the defense has asked that the state ask a few clarifying questions on direct examination of this witness, essentially indicating that most of these swabs taken by Detective Riley were not tested for confirmatory human blood testing at the laboratory, that they were simply sent for DNA analysis. And I indicated to counsel that I didn't have an objection to asking those questions. The witness who ordinarily would testify to that is expected to testify sometime next week or so.
Ask that the stipulation be presented to the court after the state's questions,
So, Judge, if I may.
unless there's cross-examination.
Well, there's another reason maybe not to do that. It's, and if I may interject, I think this is why we're agreeing to this. What this is basically a flow chart. We're skipping some of the chain of custody material. So to facilitate that flow, it may be necessary at least to put it up or to mention it beforehand, only because this witness is going to be testifying to testing things that came from, and makes it sound like it was picked up at the garage and whisked to her office, when instead there are a couple of intermediate steps that would need to be clarified. We don't need to do it in cross-examination. If it goes in this way, at least it explains that skipped step, if you will.
So you have the flow chart, correct?
It's not in a chart form, but it's essentially that. Yeah.
My intention, Your Honor, was essentially to publish the stipulation with each exhibit so that this was identified as State Police 12. It was submitted to the state laboratory. and redesignate it as laboratory submission 2, for example. And then can you please tell us the results of 2, right? You just sort of go through it that way. And so I'm going to publish the stipulation as we go along. If the court would like to review it in advance, I'm happy to tender that now.
Well, what the court has to do is explain to the jury what a stipulation is.
Of course.
And so what the court will do is wait for counsel to indicate that it may be an appropriate time for the court to explain what a stipulation is.
And I'll note we've signed the stipulation. There's 2 stipulations. There was one other, I think it's just that there was one additional remark that it's not just that several of these things were not tested, but that some were tested and were negative for blood. And the reason this is important is the stipulation uses the same name that the police used, and it often mentions Kastle-Meyer and luminol. And of course, this goes back to whether, my concern about it being in it all, but since it is, for most of these, there was never a confirmatory test, and then some that were tested came back negative. It would give the false impression, perhaps, to the jury that when there was DNA, that it was blood DNA, when in fact it was skin cell DNA, even though it was taken from something called a blood-like stain that tested positive for KM, but it's to get that clarified because of the reference to those reagent presumptive tests.
Well, are we ready to proceed?
There's just one other thing I want to put on the record, and the state did share this with us, and I just want to raise it now so it doesn't happen in the future. The witness who was here yesterday had been instructed specifically by the state not to mention a firearm. So this is a witness who then apparently deliberately violated an instruction. And that's why I wanted to let the court know that if we have concerns about any other witness, we would need to have either a sidebar or a discussion outside the presence of the jury. Perhaps if the court had admonished the witness, she wouldn't have disobeyed the instructions by the state.
Well, the court would not have known that the state instructed the witness not to mention firearms.
Your Honor, if I could just be heard on that, I don't think that Ms. Almeida deliberately violated any sort of instruction. The question was phrased by me, I think, a little inartfully. I had not appreciated the fact that she had mentioned the gun when asked whether or not, what she had relayed to the police. I was expecting to just hear that there was a missing mother, and she apparently misunderstood, and so it was completely inadvertent. As the court knows, what we're doing here is a tightrope act, and these things are going to happen from time to time. But yes, the witness was instructed not to mention the gun, and unfortunately, what happened happened. But I don't think there was any sort of deliberate, attempt to circumvent the instruction by the state. And I'll also just add, Judge, that I had actually offered for Ms. Almeida to be present in the room during the offer of proof and the argument on the uncharged misconduct, and the defense did not want her present. And I specifically indicated that I would hope that she would be present so perhaps that is another way to handle things in the future, that the witness could actually be present for some of the arguments so the witnesses understand exactly what the scope is. And I indicated at that hearing that I would not be eliciting evidence of the firearm. So I just want to say that I think it was completely inadvertent, and that's all.
Thank you. Are we ready for the jury?
Yes.
We'll bring the jury in. counsel stipulate to the presence of all of the jurors?
Yes, sir.
Yes, Judge.
Thank you. Attorney McGinnis.
Your Honor, the state calls Kristen Maydell.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm as the case may be that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Can you please state your name and spell it for the record?
Kristen Maydell, KRISTENMADEL.
And your affiliation?
I work at the forensic lab.
Ma'am, you may be seated. Thank you.
Good morning.
Good morning.
Ms. Maydell, who employs you?
The State of Connecticut Forensic Science Laboratory.
Where's the Forensic Science Laboratory located?
It's located at 278 Colony Street in Meriden, Connecticut.
How long have you worked for the State Police Forensic Laboratory?
Next week will be 20 years.
What is your position at the lab?
I am currently a Forensic Science Examiner 2 in the DNA unit.
What are your duties at the laboratory?
My main duties are to extract DNA from items of evidence that may contain biological stains or material. I perform analyses. I develop a DNA profile when possible, write reports, and testify in court when necessary. I also am a supervisor in the DNA unit, so I supervise 2 FSC1s or Forensic Science Examiner 1s within the unit on their daily duties. I am the quality control coordinator for the DNA unit also, which means that I make sure that all the reagents and consumables that we use in our DNA testing process are checked before they're put into use for casework. And I'm also the contact person for missing persons cases that require DNA testing.
I'm going to hand you several exhibits that have been marked for identification as states 18 through 28. I'm just going to show you States Exhibit 18 first. What is States Exhibit 18?
This is my CV.
And I have provided a copy of that to Attorney Sean. I'm moving into evidence at this point.
Could I just see which one it is, please? It's referenced by number, so if I could just look at the. No objection.
That states 18.
It is, Judge.
States 18 will be admitted as a full exhibit.
I'm also going to hand you States 19 through 26 for identification purposes only, and just ask that you hang on to those for now. And if I could just have a brief moment with Attorney Schoenhorn.
That's fine.
Now, you mentioned that you work in the DNA portion of the laboratory. Can you tell the jury what is DNA?
DNA stands for deoxyribonucleic acid, and it's the hereditary material found in a cell that makes you who you are as an individual in an organism. DNA is passed from parent to child, where you get half your DNA from your mom and half your DNA from your dad. And nuclear DNA is unique to an individual, except for identical twins.
Before you proceed, ma'am, there's an interpreter So we would ask that you would just slow down your delivery so that the interpreter can interpret accurately.
Okay. No
Thank
problem.
you.
What are some sources of DNA?
You can get DNA from cells in your body. So cheek cells within your mouth, blood, saliva, body fluid such as semen. There's DNA in the roots of your hair, nuclear DNA, bones, and teeth.
What is the purpose of DNA testing?
DNA testing is a forensic tool of comparison. So we want to try to include or exclude a possible person as being a contributor to that evidentiary profile. So we develop a DNA profile from a known profile and the evidence, and we compare those to see if they match.
How do you obtain a DNA profile?
We use standard protocols and procedures that are accepted throughout the United States and the world. First, you want to get the DNA out of the cell. So you open up those cells and extract the DNA. Then we want to see how much DNA we have. So we want to quantify that DNA. After we know how much DNA we have, we want to go make many more copies of that DNA. So we amplify it, think of a photocopier. And then after that, we want to separate those DNA types so we can develop a DNA profile, which is represented by a series of numbers.
Approximately how many DNA profiles do you typically compare to evidence in a given year as either a primary analyst or a technical reviewer?
Oh, thousands.
Does your equipment also have the ability to tell you whether or not one or more of the contributors to a DNA profile are male or female?
Yes.
What is a mixture?
A mixture is when you have a DNA profile that is more than two or more people contributing to that profile. So to give an example, like I said before, you get half your DNA from your mom and half your DNA from your dad. So if your mom gives you one type and your dad gives you that same type, you might only have that one type represented at any specific test site. If your mom gives you one type and your dad gives you a different type, you would have two different types at that test site. So if there's ever evidence of 3 or more types at a particular site, that's evidence that it's more than coming from more than one person.
Are you familiar with the term trace DNA?
Yes.
What is trace DNA?
Trace DNA is DNA that is left behind when it comes in contact with a person or an object.
Is it possible to touch something or come in contact with something and your DNA not be detected during testing?
Yes, that is possible. It depends on how long you touch something, how hard you touch something, what the substrate is, and how much DNA can get left behind.
What is primary transfer?
Primary transfer of DNA is when you transfer DNA from a person to an object or a person to person.
What is secondary transfer?
Secondary DNA transfer is when DNA can be transferred from a person to an object, from a person to an object to a person, from a person to an object to an object. I don't know if I said that one already, but yeah, those are some examples.
And in doing your analysis, you reach certain conclusions, is that correct?
Yes, but after we make a comparison between the evidence and a known profile, we would have a conclusion, correct?
I'd like to talk to you about different conclusions and what those mean so that the jury is clear. When you reach the conclusion included, what does that mean?
An included conclusion would mean that the types in the known profile are present in the evidentiary profile where there are results.
What does the conclusion cannot be eliminated mean?
Cannot be eliminated is a conclusion where you have a partial match between the known types and the evidence where results are detected.
What does the conclusion eliminated mean?
Eliminated is when the known types are not present. Some of them or all of them are not present in the evidentiary profile.
What does your conclusion consistent with source mean?
Consistent with source is when the known types are present in a single source profile at where results are obtained.
And what does the conclusion consistent with contributor mean?
Consistent with a contributor is also a conclusion where a person's types are present in a mixture profile where there's results.
Are you familiar with the acronym STR?
Yes.
What does STR stand for?
STR is the actual type of nuclear DNA testing that we do. It stands for short tandem repeats. And this is type of DNA testing that is used throughout Connecticut and the world. And you are basically looking at length variant repeats. So at any particular site, like I was talking about before with the different types, those types are represented by a number, and that number is because of the number of repeats at that site. So you think of it as a train, and every train has a engine car and a caboose, but the number of train cars in between those are the repeats and the different lengths. So I may have 15 train cars in between, but you may have 16. So those are what we're looking at.
Are you familiar with something known as STR mix?
Yes,
What is that?
that is a software that is used to help the DNA analyst interpreting the DNA profiles.
Are you familiar with the term likelihood ratio?
Yes.
What is that?
A likelihood ratio is the evaluation of the weight of the evidence under alternate hypothesis. So that's the statistical weight that we give to a conclusion that is at a positive association. So you have some kind of weight to what that conclusion means.
At the laboratory itself, what types of steps do you take to ensure there's no contamination from sample to sample?
Sure, we always wear lab coats, masks, gloves, hair nets when we're processing samples in the laboratory. We use bleach and UV light to clean our surfaces, and we have separate testing spaces for our known profiles versus our question samples.
When a case gets assigned to the laboratory, does it get a particular case number?
Yes.
I want to direct your attention now to a laboratory case number entitled DSS-19-002984. Did you conduct DNA analysis under this laboratory case number?
Yes, I did.
And was this laboratory case number associated with the New Canaan State Police investigation into the disappearance of Jennifer Dulos?
Yes, it was.
And in terms of doing DNA analysis, what do you need as a forensic scientist to do a comparison between a particular person and a DNA profile found on a piece of evidence?
I'm sorry, can you repeat the question?
Sure. So how do you do a comparison between a particular person and an item and a DNA profile that you find on an item of evidence?
Well, you have to develop a DNA profile for both of those. You need a known sample from that individual or person that you want to compare the evidence to.
You mentioned a known sample. What is a known sample?
A known DNA sample is a sample taken directly from a person that you know it's coming from, that source. Typically swabbing up the inside of your cheek swab.
Are you familiar with the term pseudoknown?
Yes.
What is a pseudoknown sample?
A pseudoknown sample is a sample that's typically a piece of evidence that you gather from a person that you think their profile would be on, and it would be a single source because you can't collect a buccal swab from that person. So a good example of this would be a toothbrush. You should be the only person on your toothbrush. And then we could develop a DNA profile from that to use for comparison.
In connection with this particular case, did you receive known DNA samples from several individuals?
I did.
And perhaps I'll just read them. Did you receive known DNA samples from Fotis Dulos, Michelle Troconis, Lauren Almeida, Joel Gumieni, Petros Dulos, Theodore Dulos, Christiane Dulos, Constantine Dulos, and Noel Dulos?
I did.
Now, when a known DNA sample is processed at the laboratory, who typically processes that sample?
Typically, the knowns are done in a separate section of the lab to keep them separate from the evidence. And we have a separate section of people who process those knowns. I actually processed the two from Fotis Dulos and Michelle Troconis myself, because I believe it was a sample that needed to be processed quickly, so I did them by myself and didn't wait for someone in the known section to do them.
So essentially, the ordinary process is a known DNA sample is extracted by someone else in the laboratory, and then you ordinarily review that data and compare it to the samples found on the evidence. Is that correct?
Correct, yes, it's done in a different part of the lab. It goes through the same process. It's analyzed, it's reviewed, and then that final profile is given to me so I can use it in comparison to the evidentiary profiles that I have.
You mentioned in this case that you personally did the extraction for the known DNA samples of Fotis Dulos and Michelle Troconis. Is that correct?
I did, yes.
Did you do any other extractions of what would be considered a pseudo-known sample?
I did. I processed the toothbrush.
Were you able to generate a DNA profile from the toothbrush?
I did.
Your Honor, perhaps this would be an appropriate time to present the stipulation.
Yes.
This has been marked as State's Exhibit 27 and 28. 27 is entitled a stipulation regarding evidence seized from 69 Wells Lane and 2014 Range Rover. And State's Exhibit 28 is entitled stipulation regarding evidence seized from Jennifer Dulos's Chevy Suburban.
Thank you. Ladies and gentlemen, what the state and the defense have agreed upon is contained in what is called a stipulation. It is signed by both parties. The stipulation is an agreement as to certain facts. So you will have an opportunity at the appropriate time to review those stipulations. Again, those stipulations concern an agreement between the state and the defense as to certain facts. Do you wish to publish it now or no?
I'll publish it as we proceed with the direct run.
Thank you.
Are you familiar with something known as a parentage analysis?
Yeah, parentage comparison is when we compare to see if a parent can be the possible donor to that child's DNA. So we do a comparison and then a statistic to show the frequency of people who could be a parent to that child.
And did you do a parentage analysis in this particular case?
I did. I compared the toothbrush to one of the Dulos children.
If I can just approach. This is State's 29 for identification, Your Honor.
Thank you.
Can I just look at it quickly, please? Thank you.
By agreement, Your Honor, I think State's Exhibit 29 can become a full exhibit.
States 29 admitted as a full exhibit.
KNU States Exhibit 29. You indicated that you had done an analysis of the profile that you obtained from the toothbrush to Fotis Dulos. Is that correct?
Yes, this is the report I generated with that comparison.
And can you tell the jury what your conclusion was?
My conclusion was the source of the DNA profile from the swabbing of the electric toothbrush is consistent with being a parent of Fotis Dulos. The expected frequency of individuals who could be a parent of Fotis Dulos is less than 1 in 8.1 billion in the general population.
Now, when evidence comes to the state laboratory, is it given a submission number?
Yes, when a submitting agency brings any evidence to the lab, it's given a unique case number, which we discuss is this DSS 19-002984, and then each piece of evidence is then given a number underneath that case number.
And what was the submission number for the toothbrush in this case?
Submission number 7.
Now, ordinarily, if there is swabs taken by a police department and submitted to the state laboratory for further forensic analysis, where's the first stop for those swabs?
If there's just a DNA request, those swabs would go to the forensic biology unit, where they would prep those swabs for the DNA unit. So the person would just basically cut the cotton swabs off the tip and put them in a tube for DNA.
And are you familiar with someone named Christine Roy?
I am. She's a forensic scientist in the forensic biology unit.
And she has since retired, is that correct?
That is correct.
But she did most of the cutting in this particular case, is that correct?
From what I recall, yes.
And when a swab is cut off by forensic biology and submitted for DNA analysis, does that get an additional submission number?
Yes, it gets what we call itemized. So if the parent item is number 1, then when they cut that swab off, they'll designate it as either a 1-1 or a 1S1. Since it's been 5 years, the evidence nomenclature has changed a little bit, but it gets a sub-item of that parent item.
And many of these swabs that were submitted were described by the state police as being KM positive. Are you familiar with that term?
Yes.
What does that stand for?
KM is Kastle-Meyer is a chemical screening test for the presence of blood in a sample.
Many of these swabs, though, were not tested at the laboratory for confirmatory blood. Is that correct?
That is correct.
And some actually were tested additionally by the laboratory and came back negative. Is that correct?
For confirmatory testing or KM?
I believe for KM.
There might be some results in here that we did do KM testing on some samples. I can't recall exactly, but.
Okay. And if I just have a moment to show him. And just to be clear, most of these swabs were not confirmatory tested for blood either. Is that correct?
Correct. Confirmatory test would be a separate test than KM. KM is a screening test.
Now, you've indicated that you did analysis in this case. Is that right?
Yes.
Okay. I'd like to talk to you about some of the results, if I could. If we could just pull up the first one, please. Your Honor, I'm publishing on the screen a photograph which is found in States Exhibit 9, Folder 3, specifically photograph 2. And I'm just going to publish the stipulation at this point. State Police Exhibit 9 was seized from 69 Wells Lane by Detective Riley on May 25th, 2019, and identified as 2 swabs from the scene, exterior handles of the mudroom back door, and was subsequently submitted to the Division of Scientific Services and designated as submission number 2. And Ms. Maydell, just for your benefit, this is referred to in DNA Sup 1, Sup 9, and Sup 18. Could you tell the jury what your conclusions were with respect to submission number 2?
Sure. So for the first report that it was reported in is supplemental DNA report, and it is item 2S1 was the swabs from, quote, exterior handles of a mudroom back door. The results are consistent with a DNA profile from item 2S1 being a mixture of 2 contributors with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 2S1.
May the interpreter request that you speak a little bit slower.
Sorry. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Fotis Dulos could be a contributor to the DNA profile from item 2S1.
And what about the defendant?
Michelle Troconis is eliminated as a contributor to the DNA profile from item 2S1.
And
Could we have a sidebar for a moment, Your Honor?
Yes.
obtain from that calculation is above what our elimination range is, but below what our positive association is. So therefore, we cannot reach a conclusion for that particular comparison.
And eliminated?
Eliminated is when the likelihood ratio is below our positive association, so we eliminate them, a negative likelihood ratio.
And just staying with lab submission 2S1 specifically.
Is clear to the jury. Just using a narrative form, Ms. Maydell, inconclusive means you can't tell, correct?
Correct. I can't eliminate and I can't do a positive association. There's no conclusion can be made for that particular comparison.
Thank you. Are there any questions based on the court's question?
No, Judge.
Thank you.
Staying with item 2S1, directing your attention on DNA supplemental report number 9. Did you do additional analysis with known profiles?
Yes, I made big one, sorry.
That's right. I know it's a lot.
So the conclusion I made in this report was 2 different knowns. So the conclusion is the same as the results are consistent with the DNA profile from item 2S1 being a mixture of 2 contributors, with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Petros Dulos, Constantine Dulos, Christian Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 2S1. The results do not support the hypothesis that Lauren Almeida is a contributor to this profile. Assuming 2 contributors, Lauren Almeida is eliminated as a contributor to the DNA profile from item 2S1. And also Pavel Gumeni is eliminated as a contributor to the profile from 2S1.
This is paragraph 2 of State's Exhibit 27. State Police Exhibit 10, which was seized by Detective Matthew Riley from 69 Wells Lane on May 25th, 2019, and identified as 2 swabs from the scene in the interior handles of the mudroom back door, was subsequently submitted to the Division of Scientific Services and designated as submission number 3. And this is in DNA supplemental report number 1. Can you tell the jury what the results of your analysis were for that particular item?
Do I have, it's supposed to be exhibit number 27, you said?
Ms. Maydell, it'll be DNA supplemental report number 1, which is in front of you. State's Exhibit 27 is the stipulation that I made.
Oh, okay, sorry. Was lab item number 1?
Lab submission number 3.
3, sorry. Yes, sorry, found it. That was bag with 2 swabs, and the sub item was called swabs from, quote, interior handles of mudroom back door.
And what were the results?
For item 3S1, there was no DNA profile detected.
What does that mean when no DNA profile is detected?
There just was not enough DNA there to detect a profile, so I have no results.
I'm publishing to the jury, Your Honor, photograph contained in State's Exhibit 9, Folder 3. This is photograph number 18, and it displays the garage door opener at 69 Wells Lane. This was identified as State Police Exhibit 11, 2 swabs of the exterior garage door opener open keypad from the center bay and was subsequently designated as lab submission number 63. And I'm just reading from paragraph 3 of our stipulation.
And if you could read a little slower, please, Attorney McGinnis.
I'm sorry. I apologize, Your Honor. It was designated submission number 63. And for your benefit, Ms. Maydell, it's found in DNA supplemental reports number 2, 9, and 18. Was this given a sub-item as well?
Yes, so 63S1 was a designated swabs from, quote, garage door opener keypad.
And what were the results of the swabs from the garage door opener keypad?
The results are consistent with the DNA profile from item 63S1 being a mixture of 2 contributors. The results do not support the hypothesis that the source of the DNA from the swabbing of the electric toothbrush, Fotis Dulos, or Michelle Troconis are contributors to this profile. Assuming 2 contributors, the source of the DNA profile from the swabbing of the toothbrush, Fotis Dulos, and Michelle Troconis are eliminated as contributors to the DNA profile from item 63S1.
And you did additional analysis in DNA supplemental number 9 with known profiles, is that correct?
Correct.
And what were the results after you had a chance to look at the other known profiles?
The results are consistent with the DNA profile from 63S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 63S1 is at least 45,000 times more likely to occur if it originated from Lauren Almeida and 1 unknown individual than if it originated from 2 unknown individuals. The results do not support the hypothesis that C. Noel Dulos is a contributor to this profile. Assuming 2 contributors, C. Noel Dulos is eliminated as a contributor to the DNA profile from 63S1. Petros Dulos, Konstantin Dulos, Christian Dulos, Theodore Dulos, and Pavel Gumini are eliminated as contributors to the DNA profile from item 63S1.
And just to sort of short circuit this, going forward, with the court's permission, if the other children are eliminated, you can just say the other Dulos children, or
Okay,
just to sort of streamline it.
sure.
I'm displaying for the court now State's Exhibit 9, folder number 2, picture 7, which shows the mud door handles, Your Honor. And with respect to the stipulation, it's agreed that this is State Police Exhibit 12. It was seized by Detective Riley and submitted to the State Forensic Laboratory as submission number 4. I'd like to talk to you about this DNA submission, if I could. Were swabbings taken of this particular object?
Yes,
And unlike some of the other objects where the swabs came in from the police department, Ms. Roy actually did these swabs, is that correct?
yes, that is correct.
And how many swabs did she take in total?
On my supplemental DNA report, I have 2, 4-1S1 and 4-1S2.
All right, and I'd also direct you to DNA sub 2. I believe there's also 4-1S3. And
Correct, yes,
4-1S4. So there were 4 swabs total taken of these?
yes.
Okay. Just beginning with the first swab, 4-1S1, what were the results for that swab? And this will be in DNA sub 1 and sub 9.
The results are consistent. Oh, the 4-1S1 was designated a reddish-brown ridge-like detail from front of knob. The results are consistent with the DNA profile from item 4-1S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 4.1s1. The results do not support the hypothesis that Fotis Dulos is a contributor to this profile. Assuming 2 contributors, Fotis Dulos is eliminated as a contributor to the DNA profile from item 4.1s1. Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1s1.
And when you did the additional analysis of the knowns in DNA sub 9, what were the results?
The results are consistent with the DNA profile from item, oh, sorry, I'm on the wrong one. 4.1s1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Constantine Dulos could be a contributor to the DNA profile from item 4.1s1. The results do not support the hypothesis that Christine Dulos is a contributor. So assuming 2 contributors, Christine Dulos is eliminated. Results do not support the hypothesis that C. Noel Dulos is a contributor. Assuming 2 contributors, C. Noel Dulos is eliminated as a contributor to 4.1s1. And then Petros Dulos, Theodore Dulos, Lauren Almeida, and Pavel Gumini are eliminated as contributors to the DNA profile from 4.1s1.
And just with respect to 4.1s2, which was found in DNA sub 1, no profile was obtained. Is that correct?
That is correct.
And with respect to 4.1s3, was that a swabbing of a doorknob and plate assembly with screws?
Yes, that's what it was designated.
And directing your attention now to DNA sub 2, what were the results?
The results are consistent with the DNA profile from item 4.1s3 being a mixture of 3 contributors with at least one of them being male. Assuming 3 contributors, the DNA profile from item 4-1s3 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile of the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. Assuming 3 contributors, the DNA profile from item 4-1s3 is at least 330,000 times more likely to occur if it originated from Fotis Dulos and 2 unknown individuals than if it originated from 3 unknown individuals. And Michelle Troconis is eliminated as a contributor to the DNA profile from item 4-1s3.
Well, Attorney McGinnis, what the court is going to do is just ask a few questions so that it is clear what those numbers mean, but in a more narrative form. So, Ms. Maydell, when you indicated that certain court is going to refer to it as likelihoods occur, when you use the numbers, would you explain in a narrative form what those numbers mean? So if someone is 45,000 times more likely to be X, what does that mean?
Well, it's a likelihood ratio that, given the evidence is more likely to occur if hypothesis 1 is true compared to hypothesis 2.
So would you rephrase it using those numbers?
So for the given
Did follow from those findings.
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a
Waive what
relationship.
concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or
I'm just
die with
asking you
these
to tell us
lawyers.
on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent.
lawyers,
I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Balden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
Because
Your
you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Without
those
a hearing.
positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is
So-
what the
so
Sixth
my
Amendment
concern is getting
requires.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it. It's in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts,
And
other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, Just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But if when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
Well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did,
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance to counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance to counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case, it'd be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive you can waive an ineffective assistance to counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance to counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
At least fundamental error, maybe structural error that's reversible.
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could. Because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by
But it-
any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I look at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So you're so you think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here under the United States Supreme Court's jurisprudence in Wheat. The decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed? So, which means.
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, in the Wheat case. I don't see Wheat as tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment,
But where can you point to me saying, with regard to saying somebody is incompetent or negligent, that's like, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, Wheat went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What
would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's
representation at trial in his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will
Do you
believe.
agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons,
but-
could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume, we're inferring from that choice of words and the particular thing cited by the judge, what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm
in these
clear,
cases.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? We don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half-measure justice. So we'll accept whatever the court's ruling is, but I think that that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being relating to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right.
Okay, that concludes that. And Let's see if they've started the hearing in Idaho. I'm not sure. Okay. All right. So let's take a quick look here. Just looking. Okay. They haven't started yet. So let's go back over to Connecticut here. And
Evidence, it would be 100 times more likely, 100 billion times more likely, as an example, for hypothesis 1 to be true compared to what hypothesis 2 is.
So it's a comparison of the hypotheses.
Yes, only one of them can be true. So if that evidence is more likely to occur if the first hypothesis is true compared to the second hypothesis.
Thank you.
I believe you indicated for 1S3, it was 330,000 times more likely that Fotis Dulos was a contributor to the profile than if it were 3 unknown people. Is that correct?
330,000 times, yes.
And I'll just note, I think that's a misstatement of what the odds are. I think this is they call the fallacy. It is odds of one thing occurring versus another, not that it's that person.
Well, what the court understood from Ms. Maydell's explanation is that we're comparing hypotheses. We're not talking about identification.
And just directing your attention at DNA supplemental report number 9, you again ran those additional knowns against the DNA profile from 41S3. And if you're ready, what were the results?
Sure. The results are consistent with the DNA profile from 41S3 being a mixture of 3 contributors, with at least one of them being male. The source of the DNA profile from the swabbing of the electric toothbrush is assumed to be a contributor to the DNA profile from item 41S3. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the toothbrush is one of the contributors, the DNA profile from item 41S3 is at least 900,000 times more likely to occur if it originated from Fotis Dulos, the source of the DNA profile from the swabbing of the electric toothbrush, and one unknown individual than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from item 41S3 is at least 160,000 more times likely to occur if it originated from Fotis Dulos, the source of the DNA profile from the swabbing of the toothbrush, and 1 unknown individual than if it originated from the source of the toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from item 41S3 is at least 30,000 times more likely to occur if it originated from C. Noel Dulos, the source of the DNA profile from the electric toothbrush, and 1 unknown individual than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals. Assuming 3 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Konstantin Dulos, Christian Dulos, Theodore Dulos, and Pavel Gumeni could be contributors to the DNA profile from item 41S3. Lauren Almeida is eliminated as a contributor to the DNA profile from item 41S3.
I want to talk to you about 41S3 for a second.
State of Idaho versus Chad Guy Daybell, scheduled this morning as a hearing on defense counsel's motion to withdraw Couple of preliminary matters before we get started here. The court will note there is an order governing courtroom conduct. The court is live streaming this on the official YouTube channel of the Idaho Supreme Court. I'm not permitting any other recording, video, or audio of the proceedings. So if you have a device that does that, that's not permitted. In addition, if you do have devices that make noise, please make sure they're silent or turned off to not disrupt the proceedings. And that's all set forth in the order governing courtroom conduct that's in effect for this hearing. I'll note on the record that the state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. Sean Pryor is here with the defendant, Mr. Daybell, and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion also filed January 11th. The court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then yesterday on the 17th of January filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copies of that to counsel, but it does have some relevance to today's proceedings. So let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to counsel today.
Okay, thank you. And they're doing construction right through the doorway here, so counsel could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here. Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today? Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit arguments in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well, and that I should probably, and is my voice at this point acceptable, Madam Clerk? In terms of the tone, it's not washing out?
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors, and
got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in, Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So,
right, and that's correct, Judge.
This is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand, but when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that The only reason to withdraw, well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, you know, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, you know, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy. But at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case. If you are permitted to remain on, I mean denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in public proceedings. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security while Mr. Daybell is here. We will close this portion of the proceedings, and also for the bailiffs, if you could just make sure no one's within earshot of the a doorway as well, to make sure it's not carrying through on the microphones. And I appreciate your accommodating that. We'll also, of course, stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
Okay, I'll keep the audio up for Judge Boyce, and we'll return over to Connecticut and resume that with at 1.25 so we can get caught up, and they'll probably be having a morning break, which will also help get us caught up. So here we go.
DNA supplemental 9, you assume that the profile from the toothbrush was a contributor. Can you just explain to the jury when you assume that a particular profile is a contributor to another profile? What does that mean?
So it's called conditioning. And when there's a scientific, reasonable expectation scientifically that a person's DNA could be on that item, it is sometimes better to assume that person so you can get a more accurate likelihood ratio to the other contributors that are contributing to that DNA profile. So after I did the first report where I compared the toothbrush and Fotis to the swabbing of the doorknob and plate and saw that they were both contributors, knowing that I'm going to now compare the children to that profile, because the children get half their DNA from their mother and half their DNA from their father, it's a given that those profiles are going to be there, because if they're contributing, then the children are going to have a likelihood ratio. So in order to give a more accurate likelihood ratio to if the children are contributing to that profile, we went and assumed the toothbrush because she's scientifically expected to be on that doorknob because that is her house.
The time is now 11:15. Ladies and gentlemen, we will take our morning recess. The court should indicate to you today that we will conclude today's session at 3 o'clock. So we ask that you retire to the deliberation room, and please do not discuss the case.
Okay, we can skip over the break. Here we go.
Please be seated.
Before the jury comes out, I would just note, if we had a sidebar, there was a previous motion regarding motion to eliminate regarding the question about what did inconclusive mean. It was clarified by the state, but the state started getting into it knowing that there was a motion to eliminate. Again, the court did some clarification, and as far as I'm concerned, that was fine. But again, I would ask the state to realize that if I file a motion to eliminate, it's because there's an issue that should be resolved, so we don't have to do sidebar, and it doesn't require the court's intervention. Maybe he was inadvertent on Mr. McGinnis's part. I'm just raising it because we have a moment to do so.
Well, the record has to reflect that the court did act on the motion. The motion is denied, but that denial in this court's view is not to the prejudice of the defense, because the court has the opportunity to ask questions, which would allow the jury not to be confused. For example, this goes back to yesterday's discussion, the likelihood ratio. The likelihood ratio is simply a ratio of compared hypotheses. And so if the jury did not understand that previously, hopefully the jury understands that now. Are we ready to proceed?
Yes, sir.
Thank you. We can bring the jury back in, please. Okay, will counsel stipulate?
Yes, Judge.
Yeah.
Okay, thank you. Attorney McGinnis.
Good morning again. Ms. Madell, I just wanted to ask you, when we were talking about hypotheses earlier, hypothesis 1 versus hypothesis 2, could you just explain to the jury in a little more detail what that means from your perspective? Does it mean it's one or the other? What exactly does that mean?
When we're creating these hypotheses, it's to describe how likely the evidence is to occur. Is it more likely to occur when hypothesis 1 is true compared to hypothesis 2?
So it's not an either or scenario.
No, it's if number 1 is true compared to what number 2 is.
Were there a number of results in this case in which you concluded that the contributor to the profile was a single female individual and that it was 100 billion more times more likely to be the profile on the toothbrush and everyone else was eliminated?
Yes, there was a bunch of those samples.
All right, I'd like to talk to you about those if I could. If we can call up Exhibit 15 or a photograph of State Police Exhibit 15, which is found in State Trial Exhibit 9 folder number 3, photograph 13. And just for the record, Your Honor, State Police Exhibit 15 was identified as 2 swabs of a blood-like stain seized from the scene, the handle under the sink cabinet door, kitchen island, and subsequently designated as submission 6. Were these results consistent with being a single female and the results being 100 billion times more likely to be the profile found on the toothbrush?
Yes.
If we can call up State Police Exhibit 35, which was identified as 2 swabs of a blood-like stain, G19, seized from the scene and submitted to the lab as submission 102. Were these the same results, being a single female 100 billion times more likely to result if it was the DNA profile obtained from the toothbrush as opposed to an unknown individual?
Yes, single female individual, yes.
We can call State Police Exhibit number 36. This was identified as 2 swabs of a blood-like stain, G20, seized from the scene and subsequently submitted to the Division of Scientific Services as submission 103. Same results. And that's DNA sub 7 and sub 10.
Yep. Yes.
Staying with DNA sub 7 and 10 for your benefit, Ms. Madell, if we can call up State Police Exhibit number 36, 37. And this was identified as 2 swabs of a blood-like stain, C2, KM positive, seized from the scene, subsequently submitted to the Division of Scientific Services and designated as submission 104. Was it the same result, Ms. Madell?
Yes.
If we can call up State Police Exhibit 38, photograph of that. and this was identified as 2 swabs of a blood-like stain B3 seized from the scene North Bay and submitted to the state lab as submission number 105. Were the results the same, a single female?
Yes,
And just to be clear, a single female 100 billion times more likely to be the profile obtained from the toothbrush, is that correct?
correct,
And everyone else was eliminated?
correct.
If we can call up a photograph of State Police Exhibit number 39. This was identified as 2 swabs of a blood-like stain, B11, seized from the scene, KM positive, North Bay, subsequently submitted to the Division of Scientific Services as submission 106. What were the results of this?
The same as the previous result. Single female, assuming one individual, the DNA profile from item 106S1 is 100 billion times more likely to occur if it originated from the source of the DNA profile from sorry. Assuming one individual, the DNA profile from item 101S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from a swabbing of the electric toothbrush than if it originated from an unknown individual.
We can call up State Police Exhibit number 41. Photograph of that.
Well, Your Honor, I note that the witness skipped the last sentence of her finding on that particular item. I just ask that you read the remaining sentence.
Well, Attorney McGinnis, is there another sentence that was not read from the conclusion?
I'm unclear, Judge. I'm assuming he's referring to everyone being eliminated? Everyone else being
The court
eliminated?
does not know because the court does not have the exhibit.
So these results that we're going through now are consistent with the profile of the, that you obtained from the toothbrush being 100 billion times more likely to be the source of these profiles. Is that correct?
Versus an unknown profile.
Right. And everyone else has been eliminated. These results are all the same, correct?
Correct so far.
We can call up a photograph of State Police Exhibit 41. This was identified as 2 swabs of a blood-like stain, A18, KM positive, seized from the scene, and subsequently submitted to the Division of Scientific Services and designated as item 108. Were these results the same as your previous answer?
Yes,
We could call up State Police Exhibit number 45. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 109. Is the results of this test the same?
yes,
If we could call up State Police number 48. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 112. Were the results here the same?
yes,
If we could call up State Police Exhibit 59. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, left side of the hood, subsequently submitted to the Division of Scientific Services and designated as submission 118. Were the results of this the same?
yes,
If we could call up Exhibit 60. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, left front corner of bumper, subsequently submitted to the Division of Scientific Services as submission 119. Were the results here the same?
yes,
If we could call up State Police photograph 61. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, garage 2014 Land Rover, exterior side of left front door, subsequently submitted to the Division of Scientific Services and designated as submission 8. Were the results of the analysis here the same? And that's in DNA sub 1 and sub 9.
yes,
If we can call up State Police Exhibit 62. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the garage 2014 Land Rover, exterior side left rear door, subsequently submitted to the Division of Scientific Services and designated as submission 121. Were the results of this test the same?
Yes.
We can call up State Police Exhibit 63. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, 2014 Land Rover, left rear fender, subsequently submitted to the Division of Scientific Services and designated as submission 120. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 64. Oh, I'm sorry, I don't think we have a photograph of 64. State Police Exhibit 64 was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, east wall of garage, north of door 2 mudroom. Were the results of that test the same?
So which item number for the lab?
Oh, I apologize. Submission 122.
Yes.
We can call up State Police Exhibit 65. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, south side of garage, top corner of garbage can western, subsequently submitted to the Division of Scientific Services and designated as submission 9. Were the results of this test the same? And that's in DNA sub 1 and sub 9.
Yes.
If we can call up State Police Exhibit 66. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, south side of garage, top corner of garbage can eastern, and subsequently submitted to the Division of Scientific Services and designated as submission 123. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 78. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, kitchen island countertop edge north of sink, subsequently submitted to the Division of Scientific Services and designated as submission 10. Were the results of this test the same?
Yes.
If we can call up State Police Exhibit 320. This was identified as suspected biological matter E, seized from the scene, garage, 2014 Land Rover, lower edge, left front door, subsequently submitted to the Division of Scientific Services and designated as submission 132. Were the results of this test the same?
Yes.
If we can return to State Police Exhibit number 13. I don't know if I talked about this one yet. This was identified as 1 used paper towel roll with blood-like stains, KM positive, seized from the scene, kitchen island countertop east of sink, and subsequently submitted as submission 101. Were the results of this the same? This is from DNA sub 7 and 10.
You said number 110?
101.
101. Correct, yes.
If we could call up State Police Exhibit 14. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, kitchen sink, faucet spout, and subsequently submitted to the Division of Scientific Services and designated as submission 5. Can you let us know what the results were of this? This is from DNA sub 1 and 9.
The results are consistent with the DNA profile from item 5S1, being a mixture of 2 contributors with at least one of them being male. Assuming 2 contributors, the DNA profile from item 5S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, the DNA profile from item 5S1 is at least 4.3 billion times more likely to occur if it originated from Fotis Dulos and one unknown individual than if it originated from two unknown individuals. Michelle Troconis is eliminated as a contributor to the DNA profile from item 5S1.
And directing your attention now to DNA supplemental report number 9, did you reanalyze this profile and assume that the profile from the toothbrush was a contributor?
Yes, again, knowing from this first report that it was a two-person mixture and it looked like a mixture of the parents of the children, I went and created a new hypothesis to make that second contributor more discriminating. So I ran the children all against that first deconvolution of the two-person mixture in order to determine who had the highest likelihood ratio between the toothbrush and the 5 children. So then I could then assume one of them and make a comparison to that second person. So after I did that, the toothbrush had the highest likelihood ratio as being a contributor. And when you assume somebody on a profile, it increases the likelihood ratios of true contributors, but it will decrease the likelihood ratio of non-contributors. So it is a scientifically sound conclusion to do. So after I did that, then I made my conclusions in supplemental 9.
And what were the conclusions?
The results are consistent with the DNA profile from item 5S1 being a mixture of 2 contributors with one of them being male. The source of the DNA profile from the swabbing of the electric toothbrush is assumed to be a contributor to the DNA profile from item 5S1. Assuming 2 contributors, where the source of the DNA profile from the swabbing of the electric toothbrush is one of the contributors, the DNA profile from 5S1 is at least 100 billion times more likely to occur if it originated from Fotis Dulos and the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual. Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, Theodore Dulos, Laura Almeida, and Pablo Gumini are eliminated as contributors to the DNA profile from 5S1.
So all the other known profiles that you had, including the defendant, were eliminated. Is that correct?
Yes, after I assume the toothbrush as a contributor to the profile, the children are eliminated and cannot be the second contributor.
If we can call up State Police Exhibit 40. And this was identified as 2 swabs of a blood-like stain, A15, KM positive, seized from the scene, North Bay, subsequently submitted to the Division of Scientific Services as submission 107. And this is found in DNA Supplemental Reports 7 and 10 for your benefit, Ms. Maydell. What were the results of the analysis here?
S1, you said?
Yes.
The results are consistent with the DNA profile from item 107S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 107S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Due to the limited data detected from item 107S1, the comparison to Fotis Dulos and Michelle Troconis are inconclusive.
What does that mean when you say due to limited data?
So this is was designated a 2-person mixture. So the major profile being so I probably had a major profile with a minor profile. So looking at the toothbrushes being 100 billion times more likely, that was the major profile in the within that 2-person. And there was only one, probably, I don't want to speak without seeing the actual data, one peak that wasn't attributed from that DNA profile from the toothbrush. And Fotis Dulos and Michelle Troconis have that peak, so I can't say conclusively if they're a contributor or not, but I can't eliminate them either.
If we can call up State Police Exhibit 42. This was identified as a fragment of a paper towel with a blood-like stain and subsequently submitted to the Division of Scientific Services and designated as item 65 or submission 65, I should say. And for your benefit, Ms. Maydell, this is found in DNA Sub Reports 3 and 9.
I'm sorry, can you repeat the number?
65.
65. The results are consistent with the DNA profile from item 65S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 65S1 is at least 2.5 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from item 65S1.
And in fact, all known other profiles were eliminated. Is that correct?
Let me just double check. What was the other report?
Sub 9.
And I'm going to object to this mischaracterization. I may just have a moment.
Oh, I apologize.
Well, sustained.
I apologize, Your Honor. If you could just read the results when you compared it to the other knowns.
Sure. The results are consistent with the DNA profile from item 65S1 being a mixture of two contributors. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive whether Theodore Dulos could be a contributor to the DNA profile from 65S1. The other children, Lauren Almeida, Pavel Gumini, are all eliminated as contributors to 65S1.
If we can call up State Police Exhibit 43. And this was identified as a fragment of a paper towel with a blood-like stain and submitted to the Division of Scientific Services and designated as submission 66. And this can be found in DNA reports 3 and 9.
The results are consistent with the DNA profile from item 66S1 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 66S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from 66S1.
And was there additional swabbing of the paper towel that was designated as 66S2? I'm sorry. S.
Yeah, there was a 66S2 and 66S3.
Okay. So can you just indicate to the results of 66S2, which was identified as swabbing of paper towel side A?
There was no DNA profile detected.
And similarly, the results for 66S3, the swabbing of the paper towel side B?
No DNA profile detected.
If we can call up State Police Exhibit 44.
I didn't do the results for 66S1 against the children.
Oh, I apologize. If I can just have a moment. Yes, if you could tell us the results of 66S1.
So the results are consistent with the DNA profile from 66S1 being a mixture of two contributors. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from 66S1. Lauren Almeida and Pavel Gumini are eliminated as contributors to the profile from 66S1.
If we could bring up State Police Exhibit 44. This was identified as a fragment of a paper towel with a blood-like stain and subsequently submitted to the Division of Scientific Services and designated as item submission number 67. And there were actually two separate analysis of this particular item. There was a fragment of the paper towel and then there was a swabbing of the paper towel. Is that correct?
Yes, 67S1 and 67S2.
Okay, so let's start with 67S1, which was actually a fragment of the paper towel. What were the results for that?
The results are consistent with the DNA profile from item 67S1 originating from a single female individual. Assuming one individual, the DNA profile from 67S1 is at least 1 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Dulos and Michelle Troconis are eliminated as the source of 67S1.
And directing your attention now to supplemental report number 9, the Dulos children, as well as Lauren Almeida and Pavel Gumini were also eliminated. Is that correct?
Correct.
And what were the results of 67S2, which was a swabbing of this paper towel fragment?
No DNA profile was detected.
If we can call up State Police. Actually, I don't believe we have a photograph of 46, but State Police 46 is identified as two swabs of a blood-like stain KM positive seized from the scene North Bay, subsequently submitted to the Division of Scientific Services and designated as submission 110. And for your benefit, Ms. Maydell, it's found in DNA supplemental reports number 7 and 10. Could you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 110S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 110S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the DNA profile from item 110S1.
And then when you had an opportunity to test that profile against additional knowns in DNA supplemental report 10, what was your conclusion?
The results are consistent with the DNA profile from item 110S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be the source of the DNA profile from item 110S1. Lauren Almeida and Pavel Gumini are eliminated as the source of the DNA profile from 110S1.
We can call up State Police 47. This was identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 111. And Ms. Maydell, for your benefit, these results are found in supplemental reports 7 and 10.
The results are consistent with the DNA profile from item 111S1 originating from a single individual. The source of the DNA profile from the swabbing of the electric toothbrush is eliminated as the source of the DNA profile from item 111S1. Fotis Dulos and Michelle Troconis are also eliminated as the source of the DNA profile from item 111S1.
And then when you did additional comparison to the other knowns in DNA supplemental report number 10,
Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive to whether Petros Dulos, Christiane Dulos, or Theodore Dulos could be a source of the DNA profile from item 111S1. Konstantin Dulos, C. Noel Dulos, Lauren Almeida, and Pavel Gumini are eliminated as the source of the DNA profile from item 111S1.
if we can call up State Police number 49. State Police number 49 was identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 113. What were the results of this?
No DNA profile was detected.
If I could just have one moment with counsel. If we can call up State Police Exhibit 50. This is identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, Center Bay, subsequently submitted to the Division of Scientific Services and designated as submission 114. And this is in DNA reports 7 and 10 for your benefit, Ms. Maydell. Could you just indicate to the jury what the results were here?
The results are consistent with the DNA profile from item 114S1 being a mixture of 2 contributors, with at least one of them being male. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 114S1. Fotis Dulos is eliminated as a contributor to the DNA profile from item 114S1. The results do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 2 contributors, Michelle Troconis is eliminated as a contributor to the DNA profile from item 114S1.
And then when you did additional comparisons of the knowns in DNA supplemental report number 10, were all the other known profiles eliminated, the Dulos children, Lauren Almeida and Pavel Gumini?
Correct, yes.
If we could call up State Police number 51. State Police 51 is identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, South Bay, subsequently submitted to the Division of Scientific Services and designated as submission number 115. And Ms. Maydell, this is also in report 7 and 10. Can you indicate to the jury what the results were?
The results are consistent with the DNA profile from item 115S1 being a mixture of 3 contributors, with at least one of them being male. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be a contributor to the DNA profile from item 115S1. The results do not support the hypothesis that Fotis Dulos or Michelle Troconis are contributors to this profile. Assuming 3 contributors, Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from 115S1.
And DNA supplemental report number 10, when you had the benefit of doing additional known comparison?
Yes. The results are consistent with the DNA profile from 115S1 being a mixture of 3 contributors, with at least one of them being male. Petros Dulos, Konstantin Dulos, Christian Dulos, and Pavel Gumeni are eliminated as contributors to the profile from item 115S1. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether C. Noel Dulos could be a contributor to the DNA profile from 115S1. And the results do not support the hypothesis that Theodore Dulos or Laura Almeida are contributors to this profile. Assuming 3 contributors, Theodore Dulos and Lauren Almeida are eliminated as contributors to the DNA profile from 115S1.
If we can call up state police number 52. This was identified as 2 swabs of a blood-like stain, KM negative, seized from the scene, South Bay, subsequently submitted to the Division of Scientific Services and designated as submission 116. What were the results of this? DNA sub 7.
No DNA profile was detected.
If we could call up state police number 53. This was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, South Bay, subsequently submitted to the Division of Scientific Services and designated as submission 117. And again, these results can be found in 7 and 10, Ms. Maydell.
Yes.
Would you just indicate to the jury what the results were?
The results are consistent with the DNA profile from item 117S1 being a mixture of 2 contributors. Due to the limited data detected from 117S1, the comparison to the source of the DNA profile from the swabbing of electric toothbrush and Michelle Troconis are inconclusive. Fotis Dulos is eliminated as a contributor to the DNA profile from item 117S1.
And then when you had the benefit of comparing additional knowns?
The results are consistent with the DNA profile from item 117S1 being a mixture of 2 contributors. Petros Dulos, Konstantin Dulos, Christian Dulos, and Theodore Dulos are eliminated as a contributor to the DNA profile from item 117S1. Due to the limited data detected from 117S1, the comparisons to C. Noel Dulos, Laura Almeida, and Pavel Gumeni are inconclusive.
We could call up state police 67. And this was identified as 2 swabs of a blood-like stain, KM positive, seized from the scene, interior side of north garage door, and subsequently submitted to Division of Scientific Services and designated as submission number 68. And this is for your benefit, Ms. Maydell, can be found in DNA reports 2 and 9. Beginning with report 2, what were your conclusions?
So what was the number again? Item number?
68.
68. The results are consistent with the DNA profile from item 68S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 68S1 is at least 810 million times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from item 68S1.
And now directing your attention to DNA supplemental report number 9, when you did additional comparisons to knowns.
The results are consistent with the DNA profile from item 68S1 being a mixture of 2 contributors. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 68S1. Lauren Almeida and Pavel Gumeni are eliminated as contributors to the DNA profile from item 68S1.
If we can call up State Police 79. This was identified as two swabs of a blood-like stain KM positive seized from the scene, the kitchen sink faucet handle, and subsequently submitted to the Division of Scientific Services and designated as submission 11. And this can be found in DNA supplemental report number 1 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 11S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from a swabbing of the electric toothbrush could be the source of the DNA profile from item 11S1. Fotis Dulos and Michelle Troconis are eliminated as a source of the DNA profile from item 11S1.
And then directing your attention on DNA supplemental report number 9. You had the benefit of doing additional comparisons with knowns.
Yes. Results are consistent with the profile from 11S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive to whether Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, and Theodore Dulos could be the source of the DNA profile from 11S1. Lauren Almeida and Pavel Gumini are eliminated as the source of the DNA profile from 11S1.
If we can call up State Police Exhibit 319. State Police 319 was identified as suspected biological matter D, seized from the scene, 2014 Land Rover, left front fender, and subsequently submitted to the Division of Scientific Services and designated as submission 131. Then directing your attention to DNA supplemental reports 7 and 10. Could you indicate to the jury what the results were?
Sorry, what was the number again?
131.
31.
On the record on KCR 22-21-16-23, State of Idaho versus Chad Guy Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has in fact done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions. One being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. they can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating, but in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think we've
I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case, and as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it, because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed, and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for the argument and response, Mr.
Judge,
Blake.
can I respond briefly?
I was going to allow your response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money, and I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized the workload.
You've been on a case for 2.5 years by yourself, and
I have
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be to go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law, and the way the law is written, and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognize, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's gonna, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. And it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree. The arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
Okay, let's go back to Connecticut.
That will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back to
Looks like we've got lunch break coming up.
The results are consistent with the DNA profile from item 131S1, originating from a single female individual. Assuming one individual, the DNA profile from item 131S1 is 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of electric toothbrush than if it originated from an unknown individual.
And were Fotis Dulos and the defendant eliminated?
Yes.
And in DNA supplemental report number 10, were the Dulos children, Lauren Almeida and Pavel Gami, eliminated as well?
Yes, correct.
If we could call up just State Police Exhibit 12 for one moment. I think we've talked about the fact that there were 4 separate swabbings of this, and I think we got through 1S1 through 1S3. I wanted to just talk to you about the results of 1S4. And that's identified as the swabbing of a doorknob and plate assembly without screws.
1S4?
That's correct, ma'am.
Okay.
And this is found in DNA subs 2 and 9 for your benefit, Ms. Nadell. Could you just indicate to the jury what the results were?
The results are consistent with the DNA profile from item 4-1S4 being a mixture of 4 contributors, with at least one of them being male. assuming 4 contributors, the DNA profile from item 4, 1S4, is at least 1 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 3 unknown individuals than if it originated from 4 unknown individuals. The results do not support a hypothesis that Fotis Dulos is a contributor to this profile. Assuming 4 contributors, Fotis Dulos is eliminated as a contributor to the profile from item 4, 1S4. Michelle Troconis is eliminated as a contributor to the DNA profile from item 4, 1S4.
And when you did the additional comparisons?
Assuming 4 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Constantine Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from item 4, 1S4. Assuming 4 contributors, the DNA profile from item 4, 1S4 is at least 130,000 times more likely to occur if it originated from Christiane Dulos and 3 unknown individuals than if it originated from 4 unknown individuals. Lauren Almeida and Pavel Gumini are eliminated as contributors to the DNA profile from item 4, 1S4.
I'm now going to shift, Your Honor. I'm going to be publishing things from State's Exhibit 28, which is the stipulation regarding evidence seized from Jennifer Dulos' Chevy Suburban. Ms. Maydell, you recall approximately 45 minutes to an hour ago, we talked about results in which there was a single female contributor, and it was 100 billion times more likely to have occurred if it was the profile that you obtained from the toothbrush as opposed to an unknown individual. Do you recall that testimony?
Yes.
All right. And in those instances, everyone else, all the other knowns were eliminated. Is that correct?
That is correct, yes.
All right. I want to just direct your attention now, if we can call up State Police Exhibit 105. This is identified as 2 swabs of a blood-like stain KM positive taken from the rear bumper step of a 2017 Chevrolet Suburban and subsequently submitted to the Division of Scientific Services and designated as item 124. Were those the same results that we were just discussing? This can be found in DNA Supplemental Report number 7 and 10.
Yes, that is correct.
And if we can call up 106. Same results. I'm sorry. Let me publish. This is State Police Exhibit 106, identified as 2 swabs of a blood-like stain taken from the exterior side of the right rear door and submitted to the Division of Scientific Services and designated as submission number 15. Were these the same results, Ms. Maydell?
Which report is that?
Oh, DNA Supplemental Report number 1 and 9.
S1, yes.
And if we can call up State Police 107. This is identified as 2 swabs of a blood-like stain, KM positive, taken from the running board under the right front door and subsequently submitted to the Division of Scientific Services and designated as submission 100 and... I can just have one moment, Your Honor. I just have a moment, Attorney Schoenhorn. I just have one moment, Attorney Schoenhorn. Your Honor, I apologize. I just had a scrivener's error. State Police 107 is identified as 2 swabs of a blood-like stain KM positive taken from the running board under the right front door, subsequently submitted to the Division of Scientific Services and designated as submission 125. With respect to this, are these the same results, meaning 100 billion times more likely to originate from profile obtained from the electric toothbrush an unknown profile, and all other known individuals to you were eliminated?
Yes.
If we could call up State Police Exhibit 120. This is identified as 2 swabs of a blood-like stain, KM positive, taken from the left side of the cargo area and subsequently submitted to the Division of Scientific Services and designated as submission number 70. Same results. DNA sub 3 and 9.
Correct.
We could call up State Police number 316. This was identified as 2 swabs from Area A, subsequently submitted to the Division of Scientific Services and designated as submission 100. I'm sorry? Oh, we don't have 316? Okay.
Can I have a moment with counsel for a brief moment?
Sorry, maybe just take a 5-minute recess so I can get the defense some paperwork.
Yes.
Thank you.
Ladies and gentlemen, please retire to the deliberation room and please do not disrupt the case. Please be seated. Thank you. Well, the court understands that the jury room is being provided air conditioning. So, the court is just going to indicate to the jury that we will address that in about 15 minutes. You can bring the jury in. Ladies and gentlemen, the court understands that it is quite cold in the deliberation room, so we will address that at the luncheon recess. Will counsel stipulate to the presence of all of the jurors?
Yes, Judge.
Thank you. You may proceed, counsel.
Ms. Maydell, where we left off, we were discussing State Police Exhibit 316, which was seized from the Chevy Suburban and identified as 2 swabs from Area A and subsequently submitted to the Division of Scientific Services and designated as submission 128. For your benefit, this is DNA reports 7 and 10. What were the results?
Number 128 is the same as what we were previously talking about. Single female individual, assuming one individual, the DNA profile from item 128S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. And everyone else is eliminated.
And if we can bring up State Police Exhibit 317. No, okay, I apologize. Submission, or State Police Exhibit 317 was identified as 2 swabs from Area B from the Chevy Suburban and subsequently submitted to the Division of Scientific Services and designated as submission number 129. Same results?
Yes.
State Police Exhibit 318, which was identified as 2 swabs from Area C of the Chevy Suburban and designated as submission 130. Same results?
Yes.
State Police Exhibit 99 is identified as two swabs taken of the top half of the steering wheel and subsequently submitted to the Division of Scientific Services as submission number 12. And for your benefit, Ms. Maydell, this is in reports 1 and 9. What were the results?
The results are consistent with the DNA profile from item 12S1 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 12S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush in one unknown individual than if it originated from two unknown individuals. Assuming two contributors, given the low likelihood ratios calculated, the results are inconclusive to whether Fotis Dulos could be a contributor to the DNA profile from item 12S1. Michelle Troconis is eliminated as a contributor to the DNA profile from item 12S1.
And directing your attention now to DNA supplemental report number 9. It's my understanding that with the exception of Theodore, the Dulos children, Lauren Almeida and Pavel Galimi were eliminated.
That is correct. The low likelihood ratio is calculated. The results are inconclusive whether Theodore Dulos could be a contributor to the profile of 12S1.
State Police Exhibit 100.
Could I just have a moment, counsel? I apologize.
State Police Exhibit 100, which was identified as two swabs taken from the bottom half of the steering wheel and subsequently submitted to the Division of Scientific Services as submission number 13. And this is in DNA reports 1 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 13S1 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 13S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as a contributor to the DNA profile from item 13S1.
And DNA supplemental report number 9. My understanding is that the Dulos children and Pavel Galimi were eliminated and the results were inconclusive as to Lauren Almeida. Is that correct?
That is correct.
State Police Exhibit 101, which was identified as two swabs taken from the gear shift and subsequently submitted to the Division of Scientific Services as submission number 14. And this is found in reports 1 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 14S1 originating from a single female individual. Assuming one individual, the DNA profile from item 14S1 is at least 780,000 more times likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush than if it originated from an unknown individual. Fotis Dulos and Michelle Troconis are eliminated as the source of the DNA profile from 14S1.
And in DNA supplemental report number 9, you concluded that all the Dulos children, Lauren Almeida and Pavel Galimi, were eliminated. Is that correct?
That is correct.
We can call up State Police Exhibit 108. This was identified as two swabs of a blood-like smudge, KM positive, taken from the exterior side of the right front door and subsequently submitted to the Division of Scientific Services and designated as submission 126. And Ms. Maydell, for your benefit, this can be found in DNA's reports 7 and 10. Could you just indicate what the results were?
Can you repeat the number again? 126?
6.
The results are consistent with the DNA profile from item 126 being S1 being a mixture of two contributors. Assuming two contributors, the DNA profile from item 126S1 is at least 11 million times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from two unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as contributors to the DNA profile from number 126S1.
And in DNA supplemental report number 10, I believe you concluded that given the low likelihood ratios, the results were inconclusive as to the Dulos children. However, Lauren Almeida and Pavel Guimi were eliminated. Is that correct?
Yes, that is correct.
State Police Exhibit number 113. This was identified as 2 swabs of a latent smudge from the exterior side of the tailgate and subsequently submitted to the Division of Scientific Services and designated as submission number 16. And this is in reports 1 and 9 for your benefit, Ms. Miguel.
The results are consistent with the DNA profile from item 16S1 originating from a single female individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 16S1. Fotis Dulos and Michelle Troconis are eliminated as the source of the profile from item 16S1.
And in DNA supplemental report number 9, you concluded that all the Dulos children, Lauren Almeida and Pavel Guimi, were eliminated. Is that correct?
That is correct, yes.
State Police Exhibit number 119. This was identified as 2 swabs taken from the garage door opener on the driver's side visor and subsequently submitted to the Division of Scientific Services and designated as submission number 69. And it's found in reports 3 and 9, Ms. Maydell.
The results are consistent with the DNA profile from item 69S1 being a mixture of 3 contributors with at least one of them being male. Assuming 3 contributors from item 69S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. The results do not support the hypothesis that Fotis Dulos is a contributor to this profile. Assuming 3 contributors, Fotis Dulos is eliminated as a contributor to the DNA profile from item 69S1. And the results also do not support the hypothesis that Michelle Troconis is a contributor to this profile. Assuming 3 contributors, Michelle Troconis is eliminated as a contributor to the DNA profile from 69S1.
And in DNA supplemental report number 9, you concluded that Lauren Almeida, Pavel Guimi were eliminated. You also concluded that all of the children, with the exception of Constantine Dulos, was eliminated. And with respect to Constantine Dulos, you concluded that assuming 3 contributors, it was 210,000 times more likely to occur if Constantine Dulos was a contributor with 2 unknowns as opposed to 3 unknowns. Is that correct?
Christiane Dulos?
Christiane Dulos, excuse me.
Yes. Constantine eliminated. Christiane is the 210,000 more times likely.
If we can pull up states 121. This is identified as 2 swabs of a blood-like stain KM positive taken from the cargo area floor and subsequently designated as submission number 17. And this is in reports 1 and 9 for your benefit, Ms. Maydell. What were the results of this?
The results are consistent with the DNA profile from item 17S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 17S1 is at least 31,000 times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and one unknown individual than if it originated from 2 unknown individuals. Fotis Dulos and Michelle Troconis are eliminated as a contributor to the DNA profile from 17S1.
Chairman McGinnis, we are going to take our lunch and recess at this time.
Judge, I'm sorry, may I just finish up with this one exhibit? Just one more question.
Well, remember, we are only going to be here an hour at 2 o'clock. So you may finish.
Thank you. And just continuing on to supplemental report number 9. What was your conclusion?
Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Petros Dulos, Constantine Dulos, Christiane Dulos, C. Noel Dulos, or Theodore Dulos could be a contributor to the DNA profile from 17S1. And Lauren Almeida and Pavel Guimi are eliminated as contributors to 17S1.
Thank you, Judge.
Ladies and gentlemen, we will attempt to address the frigid conditions in your deliberation room. And we'll resume at 2 o'clock. We will only have an hour this afternoon before we adjourn. So please do not discuss the case, and have a good one.
All rise. This court now stands in recess.
Okay, it looks like we got a break. Let's see. Oh, I think that catches us up. Okay, let me just check over. We still have a break. Oh, maybe not. Let's see, it looks like something may have happened in the last minute here.
All right, we confirm the live stream's begun again. We are back on the record on case CR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor, and I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor, and I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, then they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, it would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. we're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge. Thank you for your consideration.
All right. Thank you. Ms. Blake, any questions on the court's ruling? All right. Thanks, everyone, for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
Okay, so John Pryor stays on the case and no delay was granted. Kind of shot himself in the foot there on a few points. We just had Connecticut return a minute ago, so let's go back there.
And subsequently submitted to the Division of Scientific Services and designated as submission 134. Ms. Maydell, what were the results of that submission?
The results are consistent with the DNA profile from item 134S1 being a mixture of 3 contributors with at least one of them being male. Assuming 3 contributors, the DNA profile from item 134S1 is at least 100 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 2 unknown individuals than if it originated from 3 unknown individuals. The results do not support the hypothesis that Fotis Dulos, Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, and Theodore Dulos are contributors to this profile. Assuming 3 contributors, Fotis Dulos, Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, and Theodore Dulos are eliminated as contributors to the DNA profile from 134S1. Assuming 3 contributors, given the low likelihood ratios calculated, the results are inconclusive as to whether Michelle Troconis or Lauren Almeida could be contributors to the DNA profile from item 134S1. Paolo Gumini is eliminated as a contributor to the DNA profile from item 134S1.
State Police Exhibit 371, which is identified as 4 swabs from the area with blood lice staining on the steering wheel, subsequently submitted to the Division of Scientific Services and designated as submission 135. What were the results of that analysis?
The results are consistent with the DNA profile from item 135S1 being a mixture of 2 contributors. The results do not support the hypothesis that the source of the DNA profile from the swabbing of the electric toothbrush, Michelle Troconis or Lauren Almeida, are contributors to this profile. Assuming 2 contributors, the sources of the DNA profile from the swabbing of the electric toothbrush, Michelle Troconis and Lauren Almeida are eliminated as contributors to the DNA profile from item 135S1. Fotis Dulos, Petros Dulos, Konstantin Dulos, Christine Dulos, C. Noel Dulos, Theodore Dulos, and Pablo Gumeni are eliminated as contributors to the DNA profile from item 135S1.
State Police Exhibit 372, which was identified as 4 swabs from the interior side of the left front door, was submitted to the Division of Scientific Services as submission 136. And just with respect to these results, the results were consistent with a single individual, but every known profile along with the profile obtained from the toothbrush were eliminated. Is that correct?
That is correct, yes.
State Police Exhibit 373, which was identified as 2 swabs from the left front seat adjustment controls, was subsequently submitted to the Division of Scientific Services and designated as submission 137. Can you please indicate to the jury what the results were there?
The results are consistent with the DNA profile from item 137S1 being a mixture of 2 contributors. Assuming 2 contributors, the DNA profile from item 137S1 is at least 1.3 billion times more likely to occur if it originated from the source of the DNA profile from the swabbing of the electric toothbrush and 1 unknown individual than if it originated from 2 unknown individuals. Assuming 2 contributors, given the low likelihood ratios calculated, the results are inconclusive whether Petros Dulos, Konstantin Dulos, Christian Dulos, C. Noel Dulos, or Theodore Dulos could be contributors to the DNA profile from 137S1. Fotis Dulos, Michelle Troconis, Lauren Almeida, and Pablo Gumini are eliminated as contributors to the DNA profile from item 137S1.
State Police Exhibit 374, which was identified as 2 swabs from their rear view mirror, was subsequently submitted to the Division of Scientific Services and designated as submission 138. What were the results of that submission?
The results are consistent with the DNA profile from item 138S1 originating from a single individual. Assuming one individual, given the low likelihood ratios calculated, the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush the results are inconclusive as to whether the source of the DNA profile from the swabbing of the electric toothbrush could be the source of the DNA profile from item 138S1.
And everyone else was eliminated, is that correct?
Yes.
And State Police Exhibit 375, which was identified as 2 swabs from the cargo area, rear seat controls, and subsequently submitted to the Division of Scientific Services and designated as submission 139. No profile was obtained, is that correct?
That is correct.
Now, I wanted to talk to you about circumstances that can influence the presence or lack thereof of DNA. Could clothing or gloves or other objects in between a person and a surface impact the amount of DNA that is ultimately left on the surface?
If you're talking about from your hands,
So for example, if somebody's wearing gloves, could that impact whether or not they leave DNA on a particular surface?
if they're touching something with gloves, correct. Like the gloves would interfere with leaving the touch cells from your hands.
And in terms of whether or not, let's just say hypothetically, blood or a blood-like substance is left on an object and that item is subsequently swiped with either a cloth or a paper towel, could that also influence the amount of DNA that's left behind?
Yes.
How so?
Well, if you use something to wipe up something and then throw it away, you're cleaning up some of that liquid or whatever it is, blood. So then you're losing some of that DNA that was there and just leaving behind remnants of it.
And does DNA degrade under certain conditions as well?
It does.
What does it mean when DNA degrades?
The DNA is breaking up and you're getting less of it. So if it's under the influence of ultraviolet light, bleach, moisture, heat, all different factors can degrade DNA over time.
If I could just have a moment, Your Honor. I have nothing additional, Judge.
Thank you. Cross-examination.
Good afternoon, Ms. Maid.
Good afternoon.
So I'm looking at your resume, which has been put into evidence. You have a degree in biology, right?
Yes.
So I'm going to ask some questions about, for those of us who didn't major in biology, okay? So when we're talking about DNA, we're talking about something that is transmitted. Everybody has DNA, correct? We all, every living thing has DNA, correct?
Yes.
Whether it's a plant, a bug, an animal, or a human, right?
Yes.
At least when it comes to human beings, there are 2 sets of DNA that we inherit from our parents, correct?
Correct. Half from your mom and half from your dad.
So if we go back to basic biology, you have a mom and you have a dad, they have a child, and they inherit the DNA half from the father and half from the mother, right?
Correct.
And unless there's artificial insemination, you need 2 separate parents for that process to take place, right?
Correct.
And that within the DNA, there's something called alleles, correct?
Those are, yes, the specific types of the DNA profile.
And they're, for those of us who remember this from maybe high school biology, the DNA is kind of a double helix. It's sort of a twisty thing. That's how it's described. I think that's, if you use an electron microscope, that's how it'll appear, right?
It's like a twisted ladder or spiral staircase, yes.
And within that twisted ladder or spiral staircase, there are the alleles repeat at certain intervals, correct?
Correct.
And in any event, you're going to inherit half of your alleles from the male side, the dad, and half the alleles from the mom side, right?
Correct.
So one of the ways that these ancestry organizations work is they can trace your ancestry based on maybe a cheek swab or something, looking at other people in the database to see whether you're related to somebody else, right?
Correct, yes.
Because there'll be a lot of similarities between you and your parents and your children, right?
There could be, yes.
And in any event, if there are twins, whether they're identical or they're fraternal twins, they're at least close in, there'll be a lot of similar DNA, right?
There could be, yes.
So when you're running this program, the STR Mix program, right? This is a proprietary program, right?
We do not know the source code. We know how it works, but we do not know the source code.
Right. In other words, it's a private company that has patented this calculation simulation, right?
It's a private company, yes.
So you're programming in information, right?
I put in the DNA profile.
And other information too, right?
Yes, I tell it how many number of contributors I believe it is.
Right. And I want to ask you about that. You put in a number of contributors that you believe or assume are in a mixture of DNA, right?
Being experience looking at profiles, yes, I give my best.
Makes it more difficult when there's multiple contributors, right?
Sometimes it can, yes.
And in addition to that, if you have a very tiny sample that's only partial DNA, it's even more complicated, isn't it?
It can be, yes.
And some of the things when you talked about it, you said that it was inconclusive. Part of the reason was the sample wasn't even big enough to get enough alleles and repetition within a sample. Isn't that true?
Well, I'd have to know exactly what sample we're talking about.
Well, I'm using just in general. We went through a lot. Some of them, it was inconclusive because it was too small a sample for you to be able to derive a profile from it,
I
right?
think, yeah, I call those insufficient, I believe, when it's too small amount to make a comparison.
Okay, well, you're using the word insufficient, whether it's little or insufficient, it's just not enough sample for you to develop a profile of a person, right?
You're talking about two different conclusions, yes.
All right, well, fine, all right. Now, when it comes to what the lab does, you're not actually comparing the whole DNA to another person, are you?
I don't understand your question.
You're only choosing alleles from certain pinpointed locations along the double helix, right?
Well, 99% of everybody's DNA is the same, and we focus on this 1% that is most variable between individuals. And we use a kit that has a certain amount of sites that we do test. Yeah, so it's not every single site, but it's a representation of some of the
Right.
alleles that vary.
And currently, the system you use has, I believe, what, 21?
Autosomals for statistics, global filer. Yes. but
Right,
it also
global
has-
filer, you take 21 points along the DNA strand to make a comparison, right?
21 autosomal sites, yeah, locus.
No, it's not a genome of that person or anybody, right?
It's not their whole genome, no.
Okay, and in a human DNA,
Oh, I don't know the answer to that.
is it in the hundreds?
Well, the question really is, what is the range or an estimate generally? So overruled.
Give us an estimate.
I honestly really don't know if it's hundreds or thousands.
What was that number?
I honestly don't know if it's hundreds or thousands for how many loci.
It may be hundreds of thousands, right?
It could be. I honestly really do not know.
But we're only focusing on either 21 or maybe 23 locations along the strand, right?
Very discriminating locations, yes.
And when you're looking at alleles, right, you're not just looking at what the specific allele is called, because they'll have numbers and letters, right?
Numbers.
But how often it repeats along a DNA strand, right?
Right, that number is how many times it's repeated.
And that's how you determine whether it's unique to a particular person or you can compare it to another person, right?
That's how I just determine the DNA profile, is by the number of repeats at each testing site.
And some of the alleles occur in a large percentage of the I'm using the word loci because loci basically means places, right? Or pinpoints, right?
Those are the different sites that we're testing,
Right.
yes.
But I'm using the word loci so that the jury understands that that word is a Latin term for location, basically.
Mhm.
It's another way of saying that, right?
Mhm.
Yes?
Yes, sorry.
Okay. So certain of the loci, for example, are only found in male DNA, right?
Yes, there are sites that we test that are only found on the Y chromosome.
And are there some that are only found in the X chromosome?
That would be mitochondrial DNA.
Okay. And you, according to your resume, had some experience in doing mitochondrial DNA testing, right?
I do, yes.
But we're not talking about that here, are we?
No.
Some of the DNA repeats, they're given actual numbers, either whole numbers or decimal partial numbers, right?
Correct.
And that's how you determine how often it's going to repeat on the DNA, correct?
In that specific location, that's how many times that length variation repeats, yes.
And if you look at one of your reports, there's a chart that's contained in many of them, right?
Correct. We used to produce an allele table with everybody's types on it.
And if it shows the numbers, those are any numbers you put on there showing how often something repeats in your sample, right?
At that specific site, yes.
And you're also looking at a unknown sample, the one that came in on a swab or on a piece of material or whatever else that you are taking to determine whether or not that DNA shows similar repetitions as one of the people you're testing against, right?
I am comparing the DNA types from a known profile to the DNA types of an evidentiary profile, yes.
And when you use the word during your direct examination a lot, assuming X or Y or assuming this or that, you made certain assumptions as to many of these samples before you then compared it to something else, right?
Correct. I determine the number of contributors in the evidentiary profiles before I compare them.
But you also, for some of them, assumed, let's say, that the person whose DNA was on the toothbrush, right, was one of the contributors to the sample, right?
In certain non-probative pieces of evidence, yes, we do that.
Well, you're using words like non-probative. You made the determination to use that regardless of whether you think it's probative or not, right?
No, we only can condition a known profile on an item if it's a non-probative comparison, typically a victim, that you would expect scientific expectation that the profile should be there. So like if my car gets stolen and it's recovered and they swab the steering wheel, you would expect my DNA profile to be on that steering wheel with anybody else who may have drove it. So if we would condition my DNA profile if it was truly there. If I looked at the results and saw my types there, I would condition my known in order to get the second contributor better explained.
So you were assuming, by what I assume by that answer, you were assuming that your DNA would be on your steering wheel. Is what you're
If
saying.
looking at the data, it was there, yes. But looking at the data, I have to see my types there. I wouldn't just say I'm there. I would look at the data and see that my types are there.
But if you assumed that the contributor was someone else, whether it was a close family relative or not, it would change the likelihood ratios, wouldn't it?
Well, it would have to have a scientific
yes or no,
expectation.
wouldn't it?
Well, to indicate to an expert what the expert's answer is, when an expert is qualified by education, knowledge, training, experience, and skill, is inappropriate. Secondly, the witness took an oath to tell the truth, whole truth, nothing but the truth. To tell the witness what the answer should be is inappropriate. You can move, no, you can move it to have it stricken as non-responsive. But this court does not permit counsel to tell a witness what their testimony should be.
Yes, Your Honor. Let me
You can ask
rephrase-
the question again.
Right, but let me rephrase the question. Regardless of whether I use the example of your steering wheel or not use any example whatsoever, the assumptions that you made about a contributor would, if you changed that assumption to a different known contributor, it would alter the likelihood ratio that would come out of the STR mix computer program, correct?
Again, it's hard to answer as a yes or no.
So it wouldn't change it? It would come out the same?
No, it could, but it all depends on the data and if that person is scientifically expected to, be on that profile and their profile is there.
But once you run the program and you come up with a deconvolution report on using STR mix, when you then test it against someone else, you don't go back and pretend you don't know who the source is. You start with what you've already, we'll call it deconvoluted, right?
You have one original deconvolution, yes.
Right. So when you add someone, you're starting with the likelihood ratios that the computer has spit out for you previously, right?
You don't get the likelihood ratios until you make a comparison to an individual.
But you don't do a full deconvolution analysis again over the same sample if you're running it against other people. Is that a fair statement?
I'm sorry, can you say it again?
Yeah. If you decide to check a sample, an unknown, against other people, you start with the report that was already developed from the STR mix computer printout previously, correct?
Correct, yes.
Okay. Let me just ask you some questions about some of the other things that came up on direct examination. A lot of the descriptions, both in the stipulation that we've entered into, the lawyers have entered into, and in your report, make reference to descriptions such as swabs from a blood-like stain, luminol plus whatever, KM plus. These are things that you mentioned. Those were how it came to you with a title on it, right?
Yes, that was how the submitting agency named that piece of evidence.
So you didn't label that this had was a blood-like stain, did you?
I did not, no.
The police called it that, right?
Yeah, whoever the submitting agency was, yes.
Same thing with if they said Castlemeyer KM plus, that's just the police writing that down on the sample that they put on the bag that they then submit to the lab, right?
Correct, yes.
Same thing with if they use luminol, that is just something they wrote on the bag, right?
I'm just going to object, Your Honor, at this point.
Right.
Can we have a brief sidebar?
Well, first, the nature of the questions are simply as the court understands them. This witness did not write the descriptions on the bags. And this witness has stated she did not write the descriptions on the bags. So the court does not really see, unless there's a relevance objection, the necessity for a sidebar.
Well, may I be heard, Your Honor?
Yeah.
I'm objecting because I think it mischaracterizes what happened. I think the question sort of assumes that the police are just writing these things as though no test was done. And I don't think that that's what the evidence is.
Well, that's essentially, in the court's view, an extraction from the questions. The questions appear to be very simple. There was information on the bag when you first saw them. That's how the court hears the question. So what is flowing from that? the court cannot contemplate, other than the fact that there was information on the bag and she did not write it. Overruled.
Am I correct? It was just something that was written on the description that you then note. You didn't change the description that the police put on it, correct?
No, we use what the police describe it as, so it continues through.
Right. You just give it your own letters and numbers to distinguish what you do from the exhibit and description that the police put on there, right?
Yes, we have unique item numbers for our pieces of evidence under our case number.
Right. And I just want to be clear, you indicated that you're familiar with a little bit with Castlemeyer KM, is that right?
I am, yes.
But you're not a biologist, right?
I'm a forensic scientist who I've had training on KM. I have a proficiency test twice a year in order to perform KM, so I can perform KM testing and have been
just-
trained.
I didn't want to interrupt. Did you finish your answer?
Yeah. Mhm.
And KM is not used, that's one of these presumptive tests, right?
We call it a screening test.
The screening test, it does not mean that a substance is blood, does it?
No, it just is testing to see if there could be the presence of blood.
There could be, but you're familiar with the fact that many other things test positive if you use KM on it, right?
Yes, other things can make a positive result.
And we're not just talking about animal blood, are we?
No, there's other plants and horseradish. There's a couple things that will make the test turn positive, but we're trained to swab things that are reddish brown in color and not just any swab.
But you made no determination as to whether or not any of these items yourself, you didn't determine whether they contain blood or not, did you?
I do believe that there are some items in here that we did do KM testing on at the lab. That would have been Christine Roy, but I have some of those results in my lab, in my reports.
No, I'm saying you personally did not.
No, me personally, no. All these evidence items went to forensic biology first, and they did all the testing.
And you know that you would not rely on a KM test to make a determination as to whether something actually was blood or not.
No, KM testing cannot tell you that it's 100% blood.
Well, it can't even tell you if it's 99% blood, can it?
No.
Potatoes are one of those things that test positive, right?
I don't know definitely that. I know horseradish and we were trained to know that horseradish and some plant peroxidases do, but I mean.
And rust can too, right?
Rust is kind of tricky. Sometimes so when you do KM testing, you add that first colorless liquid and rust makes it change pink then, versus you're not supposed to change pink until after you add the second solution. So rust is kind of like a false positive.
But anyway, rust, from your own personal knowledge, is kind of a reddish brown color too, isn't it?
It is, yes.
And you wouldn't say that it's scientifically reliable. That is, any reagent presumptive test is not reliable for finding blood, is it?
I would say the screening test is reliable for saying that it's KM positive and there's a chance that blood would be there, but we can't say that it was blood, no.
You're saying there's a chance that there is. My question is, you wouldn't testify that as a result of a KM test, that something was in fact human blood, would you?
I would not know.
You're also aware that most of the items that you went through that you tested for were not even screened for whether there was actually blood or not through the biology portion of your labs. Is that correct?
Yeah, the ones that come in that are already labeled KM positive or luminol positive or even negative, we don't repeat that test because we do the same tests and we trust that the PD did their correct testing and we wouldn't waste samples from the swabs to do that test again and take some of that sample that would then maybe not lead to a full DNA profile.
Ms. Madel, you're not in the biology department that does the testing for blood, are you?
I do know the protocols though.
All right, but you're not in that department, right?
Forensic biology and DNA kind of are intertwined and I'm trained on some evidence exam and I'm competent on KM, so I'm not, but I'm majorly a part of the DNA unit.
And I just want to be clear, you would not testify under oath that something was in fact blood based solely on the fact there was a positive KM test, would you?
No, I would not.
And when I asked you, most of the samples that we went through earlier through the state, you went through 100 maybe samples. I asked you whether or not most of them were not tested at the lab, and I don't think you answered that question. Am I correct that most of them were not tested with a confirmatory test for what it was, correct?
None of them were tested in these samples as confirmatory.
Earlier, when you were asked what are the sources of DNA, you made reference to blood. Let me just look at my notes here. You said blood, semen, I think you said hair, and you said bones, right? Didn't you leave out like the major source of DNA in that answer?
Did I, blood, semen, saliva, bones, teeth, hair?
How about skin?
Cells, skin cells.
Skin cells, okay. Let's talk about skin cells. All of us have skin cells, right?
Yes.
And all of us have the same DNA in our skin cells that we do in our hair, in our blood, in our, shall we just say, our bodily fluids, right?
Correct, yes.
So you could take a cheek sample swab, right? And you would run a DNA profile on that cheek swab. You follow me so far, right?
Yes. Mhm.
And it would be the same result for the DNA profile as if I took a sample of blood, right?
From the same person, yeah.
Well, that's what I meant,
Yeah.
from the same person. Okay. And when it comes to skin cells, for most people, they're shedding skin cells all the time, aren't they?
Yes.
And in fact, if you cough or sneeze, you're also through what they call aerosolization, right? You're expelling DNA that way too, aren't you?
Yes, that's possible, yes.
When it comes to DNA, there's also something called primary transfer and secondary transfer. Is that correct?
Yes.
And I'm not sure you explained the distinction between those, but if we're talking about touch DNA, right, when you get a sample, does the biology forensic portion of your lab note on the file jacket whether something is touch DNA or some kind of fluid DNA?
They do.
And when you gave your testimony today, you did not distinguish between whether any of the samples that you tested and re-identified with the letters and numbers that we went through, whether they were touch DNA or something else, right?
Correct, I do not. I just test the evidence that they submit forward to me.
However it comes to you, you do a DNA profile and then you run the test on that regardless of what the source is, right?
Yes.
And when there's a mixture, as you pointed out, of more than one source in a DNA, one might be from a liquid source and one might be touch DNA at the same time, right?
That is possible, yes. We can't distinguish where the DNA came from.
And if, for example, if I were to sneeze into my hand, as some people hopefully don't do, and then touch a doorknob, chances are that there might be a mixture of just me of both the skin DNA and maybe a liquid DNA on that doorknob, right?
That's possible, yes.
And then if someone else goes and touches that doorknob, they're not only going to maybe have a disgusting mess on their hand, maybe get some cold germs, but they're going to maybe get some of that transfer of the other person's DNA onto them. Is that right?
That's possible, yes.
Right. And then if I were to come over, or I don't want to use me, if that person was then to go over and shake someone else's hand, that's what secondary transfer is. If now my
inconclusive is when we do that likelihood ratio, and the likelihood ratio comes out to be in this range that is below a positive association, but above being eliminated. So
Right.
that's why we can't make a conclusion.
Right. And the danger, of course, with inconclusive is there can be false positives and you could make mistakes if you try to subscribe a inconclusive result to anyone in particular, right?
Well, we just have that range that we say is inconclusive because it's not above what we deem positive,
Well, when you say it's been established by the lab, right?
that it's not a positive association, correct?
And when you say someone is excluded, it's because there is an allele present that you know from the profile of the actual person is missing or is missing completely, right?
Well, it's not just one allele, it's the profile overall.
Oh, I meant to say that if you count all of the alleles that you produce, even if it's more than one person, that the individual you're comparing it against is actually, does not have that allele at all, right? That's how you eliminate somebody.
Not just from one allele, you have to look at the profile overall, the data, the number of contributors, the peak height, so it's a little bit more complicated than just not having one allele.
So other than in a couple of situations where there was inconclusive information, and I think you mentioned that every one of the people you mentioned had at least one inconclusive, right? Whether they were a contributor or not, right? All the children.
Were at least inconclusive once overall.
I'm trying to make a broad question. You went,
Okay. Yes,
there
the
were
children
some
were
where all the children were at least on one occasion inconclusive, right?
Yes.
And in others, they were actually eliminated.
Yes.
And then there was a fourth category where I think you said it cannot be eliminated.
Yes.
That was because it was a higher threshold than inconclusive, but less than identified as a contributor, right?
So the cannot be eliminated is a positive association that it was just a terminology that we used to use. And we've currently changed the way we report that as consistent with the contributor, which I defined also, because it was confusing to people for us to say cannot be eliminated because we were saying eliminated, but it was actually the opposite. You cannot be eliminated. So it's still a positive association. It's just the wording is a little
Yeah,
different.
but I want to say, when you say a positive association, it's below a threshold where you could testify that that person's DNA was actually present, correct?
No, it was a positive association. They were a match. They were a partial match, but they were a match and had a positive association.
When you say partial, you're again talking about that you could not testify that it was a match because it was only a partial identification or partial connection, right?
It was a partial match, but it had a positive likelihood ratio.
Again, that's the computer saying it's a likelihood ratio, right? Positive likelihood.
Well, we used STAR mix to calculate that because it would take us too long to do all those hand calculations.
And I take it you've never tried to mimic a STR mix report by hand calculating out the odds.
In my training, I only had to do it once.
All right.
Correct. I have not done a million times.
A million times. No, and the machine runs odds a million times, doesn't it?
It has many iterations to try and describe the components of the profile. And then it calculates the likelihood ratio.
All right. Let me ask you a different question. Let me put it to a different way. The program runs what's known as an algorithm, right?
Correct.
That's the proprietary source code for STR mix, right?
Within the mathematical process, yes.
And you don't know, you could not describe how that process actually, you don't know the code is what I'm trying to get at here.
I do not know the code of the algorithm. No, I do not.
But these kind of programs that run these kind of likelihood of a certain result are similar to what's used by the lottery for calculating the odds of winning the Powerball, right?
I honestly do not know what kind of calculation they use for that.
Are you familiar with the term the Markov chain Monte Carlo?
Yes, that's the mathematical process used in STAR mix, yes.
Okay. Do you know why the word Monte Carlo is part of the name?
Right, because it was originating from a gambling. Yes, but I didn't know that that was used for the lottery.
All right. But, all right, so the gambling, right?
Yep.
you're talking about Monte Carlo as a capital in Monaco in Europe, which is a big gambling mecca. What they're doing is that kind of program calculates the odds of winning the jackpot on whatever machine, gambling machine, is being run with a giant jackpot, right? You don't know?
I guess, yeah, I don't know that.
All right. But if, using that as an example, though, if two people, if the odds of winning the billion-dollar Powerball, according to a program, an algorithm such as this, were 1 in 100 billion, right? Just assume for my hypothetical here. Does that mean if two people were to win it, that they were cheating?
That's different odds. You're saying 1 in 100 billion, where we're having the likelihood ratio with two competing hypotheses. So given my likelihood ratio is different than that.
And again, we're talking about hypotheses. Again, you're basing the hypothesis based on a process, right?
No, we base it on the background information of a case and the actual profile itself.
Well, who decides on the hypothesis? You
I
or
do,
someone else?
yes.
You make the
The
determination. of
DNA
the
analyst,
hypothesis.
yes.
And you have to read something about a case just to make that hypothesis, right?
You need background information on what the kind of case is, yes, and the pieces of evidence, yes.
Because otherwise, it's not like you're blindly taking a piece of evidence, putting it into a machine, and then coming up with a result without you having subjective input, right?
Correct.
Okay. And just so that I'm clear, I'm going to go back to the issue of, you already testified that what the SPR mix is doing is not matching a sample to a particular person or two people or three. It's giving a likelihood of a ratio based on two hypotheses, right?
And how likely that evidence is to occur given hypothesis 1 compared to hypothesis 2.
And when you say likelihood, we're talking about odds, aren't we? Mathematical odds,
Mhm,
correct?
yes.
And so these odds are not based on population numbers either, are they?
No, it's not a frequency estimate, no.
So when we hear large numbers like 10 billion or 4 billion or 150 or 250,000 or 100 billion, we're not talking about other people on Earth, are we?
No, we're not.
Those numbers have nothing to do with populations, correct?
Correct.
And when we talk about skin cell DNA, you refer to that as touch DNA, right?
So the forensic community is trying not to refer to some low-level DNA that might be collected from a surface as touch anymore, because we don't want to imply that someone actually did touch this counter and left their DNA. So we're calling it more trace DNA when it's small amounts recovered from an object or surface.
You are aware, though, that even at least at the time of 2019, the folder, some of the forensic folders from your lab still are using terms like touch in relation to this very case, right?
Well, yes, I mean, that's kind of also just for them to distinguish between when they have a piece of clothing that has bloody areas and then has non-bloody areas. They're just making that notation to say, like, I'm trying to avoid swabbing where the blood is. So this is an area that didn't appear to have a reddish brown stain. So I swabbed it, the touch area where something might have been touched versus having a body fluid on it.
And if somebody, for example, if I stay away from the word touch and instead use the term skin cells, that would be a better way to describe it, right?
Describe.
The word touch DNA.
Yes, I mean, touch DNA, yes. If you're saying someone touched something, you would get skin cells there, yes.
But if, let's say, I don't know, a police officer is walking through a house touching things, chances are that person's DNA might be found on those areas that were touched, right?
It could be, yes.
And if you have a result where you have unknown contributors to the DNA. It could be anybody who walked through that door who isn't separately tested to see if it belongs to them, right?
That's possible, yes.
Who told you to limit your DNA comparison to the children, to Lauren Almeida, to Fotis Dulos and Michelle Troconis, and Pavel Gumieni?
I only can make comparisons to the knowns that are submitted from the agencies. So that's what I do. When I get a known that's submitted by an agency, it gets processed, and that's who I make the comparisons to. I don't ask for additional knowns unless it's for an elimination known, like the situation for a stolen car. We get a swab of a steering wheel. It's a two-person mixture. I don't know if that person who owns the car is on there too, so I would ask for their known. But otherwise, I wouldn't ask for particular knowns unless there was a.
And I don't think you were asked this by the state, so I just want to ask you this. When a swab is submitted to you, it's from some surface has been wiped. Let's set aside for a moment if an actual object or cloth, as you said, item of clothing or something is submitted. We're just talking about a swab.
Okay.
You have not observed how well or how poorly that swab has been administered, correct?
Yeah, if I did not make the cutting of the swab, I did not see it. Therefore, I don't know, what the swab looked like.
Do you get the actual cutting, or do you get the chemical or liquid that cutting of the swab was put into?
No, I get the actual swab in a tube.
But you get a
Cotton.
snip off of, it's like a giant cotton tip applicator, right? So those of us who've had COVID testing know it's like these long sticks with a cotton tip at the end, right?
Correct, yes.
Bigger than a Q-tip that you might find in the hotel bathroom here, right?
So yeah, the forensic biologist would cut that swab, that cotton part off and put it into a tube.
Put in a tube, then it's given to you.
Correct.
And then you do something where you copy that sample, is that right?
Well, first, we extract it first, get the extract, then we see how much DNA we have, and then we make all those many copies so we can hopefully generate a DNA profile.
And at least as of 2019, when most of this, 2019 and 2020, when most of these comparisons were done, you were able to extract some DNA from as little as 3 cells, right?
I'd have to go back and look at my quant values for all this thing to testify that I did have something that was that small amount.
Is that are any of the reports up there for you to do that?
No.
Well, you used at the time, is it Fusion 6C?
Fusion 6C was the STR kit for 2019 and 20, yes.
And you would take a sample. These are tiny, tiny amounts, right?
There could be tiny, tiny amounts of DNA, yes.
And so the jury has some kind of semblance of size. One cell, as I understand it, is 6.6 picograms in, is that weight or size?
Weight,
Weight.
yes.
And so that we're clear, you've got grams, you have milligrams, you have nanograms, and you go down to picograms, right?
Correct.
And one picogram is a trillionth of a gram, right?
1 picogram. Yes,
You should know this
I
is
believe so,
math, right?
yes.
You should know
Yep.
that, right? Am I right?
Yes.
Okay. So if you have one cell is 6.6 picograms, we're talking about 6.6 trillionths of a gram, right?
Yep.
And if you're not disagreeing that you can get a sample out of it, as little as 3 cells.
So 3 cells would be 18 picograms, approximately.
Well,
6.6 times
so
3, yes.
more like 20.
So
right?
20 picograms.
Okay.
You might get a few peaks. We target for fusion, we were targeting 500 picograms.
That's your goal.
To get a full, correct, yes.
But if you don't have that, you run the test anyway, right?
Correct, yes.
And that's how you get these partial results. Isn't that true?
That is true, yes.
And that's why in a lot of the places along the loci, it'll show NR, meaning no result.
No result is NR, yes.
So you then have just a partial DNA and the machine is still trying to run the ratio, the likelihood ratio against a partial DNA result, isn't it?
We could try and run a likelihood ratio of a partial, yes.
And doesn't STR mix actually add in, like presume, what if there was this extra allele in there? Isn't that part of its whole process?
The whole process is trying to explain what makes up that profile, yes, by how the PCR program works, which is the amplification process. It knows how it works. It is trying to use those, word I'm looking for, use the way PCR works in order to come up with the best explanation for that profile, whether it be a full profile or a partial profile. It produces these individual components with weights to them.
So this isn't like AI though, right? It's not artificial intelligence, but it's something like that, right?
No, we know how it works. We know the mathematical process that's being used, the MCMC as you refer to, and the biological modeling of the PCR reaction. And it's doing all these iterations to best describe that DNA profile.
I understand, but getting back to what I was trying to say is, it is filling in. It says, what if the missing allele was X or 7 or 12, whatever, and then runs the program again to see if it was that, how would it come out in the likelihood? Isn't that part of the process?
Not to do with the likelihood ratio. It's weighing, it's doing all those weights first.
But it also assumes missing data and it adds it in as a part of its probability, isn't it?
It's giving weights to possible explanations. So it does look at other things, but it's like a game of hot and cold. It's proposing this type to make up the profile, and if it is a hot or a good explanation, it goes towards that iteration. If it's not a good, it'll be a cold, and it will go in a different direction to try and best explain the different DNA types that are making up that profile. And then those weights are used then, after it comes to a conclusion on what is the best explanation, then it uses those weights to calculate that likelihood ratio.
And so you're accepting the calculations from the program for your conclusions that you've told us about today, right?
Yes.
When it comes to this sample, we talked about how little it could be. And just for reference, would a period on a daily newspaper be larger than the 20 picograms that we're talking about in terms of just being able to visualize?
You can't visualize 20 picograms.
It's way microscopic, right?
Correct.
And the only way that you're able to even run this process is you do some kind of the equivalent of like photocopying the sample you have, right?
Correct.
So you have a process that's, not challenging, it's just established. So you sort of mimeograph for those of us who are a little bit older, or you photocopy the data so you have enough to then run through your program, right?
We have enough so that we hopefully can develop a DNA profile.
Now, there's also a major and minor contributor to various samples if there's more than one contributor to a sample. Is that true?
Sometimes that can be determined, yes.
Who decides what those percentages of major and minor contributors is going to be?
Well, we can look at it as a DNA analyst and estimate, but when we run through star mix, it also gives a weight to what each contributor is contributing to that profile.
And again, this is calculating based on the quantity of what is now in the system based on your multiplication or photocopying of it into making it a larger sample, right?
Based on, yes, the number of contributors I'm calling it, and then the DNA profile result that we obtained, yes.
And when we're talking about major and minor contributors, if it's, I don't know, 60 or 70%, and the other contributors are 20 and 30%, the person that, let me rephrase that, the sample with the higher percentage is considered the major contributor, right?
That would be yes.
And that all the lower numbers are the minor contributors, right?
Yes, but sometimes you can't determine a major contributor and a minor contributor.
Well, when you say you can't, but can STR mix?
Well, STR mix doesn't ever call anything a major and a minor. It just gives you those percentages to make it to 100.
do you ever disagree with its percentages? Are you able to recalculate that, saying this is wrong?
We do, that's one of the parameters that we do check to make sure StarMix runs correctly.
So Attorney Schoenhorn, if the next series of questions do not concern major and minor contributors, it's 3 o'clock.
That's correct. So I think this would be a good place to stop for the day.
Thank you. Ladies and gentlemen, we conclude the evidence for today. We suggest again that you would check the judicial branch website tomorrow, because the weather may be such that there may be a delayed opening. And we would ask that you please do not discuss the case, and have a good evening.
I forgot that we were ending early today. Yeah, it's been a bit manic here with starting over in well, I guess we started here in Connecticut, then we went to Indiana for
You may be excused.
oh,
Thank you.
for the Delphi.
Cross-examination is expected to continue tomorrow for this witness, correct?
Yes.
And how long do you estimate on cross, Attorney Schoenhorn?
15, 20 minutes?
Okay, thank you. And the state has a lineup for tomorrow? Okay, thank you. We'll stand adjourned till tomorrow morning, right now at 10 o'clock.
Could we start at 10:15 with the court's permission?
We can. So adjourned until tomorrow morning, 10:15.
All rise. This honorable Superior Court now stands adjourned.
Okay, we get to sleep in 15 minutes. Oh, I think my brain was starting to melt there towards the end because of all of those numbers and so forth, and the repetitive language. My brain just started tuning out. Oh dear. I liked it better when we had the earlier witness on. Okay, so to recap today, we listened to the arguments in front of the Indiana Supreme Court for whether or not Richard Allen gets his original team of lawyers back or not, and that decision is now pending. The justices will evaluate and render a decision. Normally it could take weeks, but I think that under the circumstances, it kind of gets expedited because of the fact that he hasn't waived his right to a speedy trial, and they want the date right away. Then we hopped over to Idaho for John Pryor put in a motion to withdraw as counsel for Chad Daybell, and they had arguments, and John Pryor said that he wants to stay on. He'd work for nothing, but it's really hard, blah, 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 blah. So he'd rather get paid, and the only way he can get co-counsel is to withdraw and so forth, because his efforts previously to find co-counsel, who has to be death penalty qualified, have been unsuccessful, with Koberger's taking his share of the death penalty qualified lawyers in Idaho, I think. And I'm not sure who else might be taking up some, but they seem to have a shortage of death penalty qualified lawyers. Anyway, what it kind of came down to is he wants to get paid by the state, and he wants to have co-counsel, and he won't be ready in time and would be ineffective if he has to do it all himself. And the thing is that he said over a year ago that he could do it and that he wouldn't withdraw and so forth. And now he's going, wah. And, you can't have it both ways. And so the Judge Boyce ruled that he has to stay on the case. And if he can get another person to come on board, that would be great, but they're not going to have a delay. So big thing in there in that case, because as Judge Boyce said, that it
Pioneer Theater Company presents Native Gardens, a hilariously biting
that a change in counsel at this point would probably delay the trial a year or more, and that the victims have a right to justice just as the defendant has a right to, a speedy trial. The victims have a right. And so that's what happened in Idaho. And so tomorrow we get to start 15 minutes later. And let's see, it's Friday tomorrow. So one more day, and then we've got the weekend. I'm going to be going up to Idaho to visit my brother, who was diagnosed on Wednesday with aggressive pancreatic cancer, which there's some small tumors that have appeared in the liver and doesn't look good. There's a survival rate over 5 years is 10.8%, so it really doesn't look very good. Apparently, it's hard to detect until there are some symptoms, which is late in the progression. And so, I don't know. I don't know if he's going to be around when my niece gets married in mid-March or not. I hope he rallies. I hope that they buy him some time. Maybe he doesn't have 5 years, but maybe he's got 3 years. We'll see. Anyway, I can't think of any other hearings that are going to be tomorrow, so I think we'll just have a straight day of the Michelle Troconis. And so I bid everybody a great afternoon, and take care, stay warm, and we'll see you tomorrow. Bye-bye.